Good morning, everybody. We're just waiting for a few more of our members, so we'll give them a minute or two, and then we'll start at 9:05 just to give people a chance to get in and get up on the panel here. And thank you, everybody, for coming. Good morning again. I think we have Dr. Arguello and Dr. Barnard are joining. And Kristen, if you want to get us started, we can get meeting.
Okay, good morning. Thanks, Allison. Welcome again, everyone. Kristen Vella. I'm a health program manager for Sonoma County Public Health. I want to welcome everyone, members and the public, and I'm gonna give everyone a chance to introduce themselves. If you could provide your name, your title, which organization you're from, and what expertise that you're bringing to this process today, that would be great. Since we're kind of in a line here, I'm going to go to my right and start with Melinda.
Good morning, Melinda Bird, she, her pronouns. I'm with Disability Rights California, and my expertise is disability rights and also youth rights, the rights of youth in institutions and community mental health. I've done a lot of advocacy around expanding community-based mental health services for youth. And I'll pass to Forrest.
Hello, my name is Forrest Coleman. You hear me now? Better?
Right up. Yep.
Oh, get right up in there. Hello, my name is Forrest Coleman. I'm a field representative, a BSCC field representative, and I work on the juvenile team for the FSO. And I currently inspect juvenile facilities, mostly in the northern region. Um, and I'm welcome everybody here today. Thank you.
And we go to Amanda Y.
Good morning, everybody. My name is Amanda Yoakum. I'm a chief mental health clinician at San Joaquin County Behavioral Health. And I am representing mental health services. And we are embedded here at the Juvenile Justice Center in San Joaquin County. And I will go to Joni.
Good morning, everybody. My name is Joni Spears, she, her pronouns. I'm an attorney at the Contra Costa Public Defender's Office. I represent youth in our Secure Track program. I've been a post-dispositional attorney for over half of my career. I've been an attorney for 22 years. And so I've represented youth at DJJ in our long-term custodial program before SYTF, currently in SYTF. I also represent youth in competency to stand trial proceedings. In terms of my expertise, I mean, what I really want and what I'm really, the reason why I'm grateful to be on this committee is that I really want SYTFs to work, and I can see some of the issues with mental health as it relates, the intersection between kind of mental health and my own defense practice. And I really value the opportunity to participate in a collaborative setting as opposed to an adversarial court setting. So that's my expertise. And I will pass it on to Liz Barnett.
Thank you, Joni. Good morning. I'm Liz Barnard. I'm an associate professor of pediatrics at UCLA. I do research and advocacy around young people in the juvenile legal system, and then I also provide clinical care in our youth detention facilities. And I will pass to Dr. Arguello.
Good morning, everybody. Juan Carlos Arguello. I work for the Office of Youth and Community Restoration. I'm the health policy officer. My expertise are psychiatry, behavioral health, LGBTQ2S+, and general health systems. My pronouns are he, el. I'll turn it over to Sean Moore.
I thought I was going to get away with this. My name's Sean Moore. I'm with BSCCIT, and I'm just here along for the ride and make sure everything runs okay.
How about Kylie next?
Good morning. My name is Kylie Wilson. I am the director of Sonoma County Juvenile Hall and the Secure Youth Treatment Facility. My expertise is juvenile institutions, as I have been here for 19 years. And I will toss it to Meredith.
Thanks, Kylie. Hi, everyone. I am Meredith Desatel. I use she, her pronouns. I'm a directing attorney at the Youth Law Center. My expertise is youth law, spanning, a number of different legal areas, including delinquency, civil rights, and conditions of confinement, health and disability law, and dependency and foster care law. And I will pass to Nayeli.
Good morning, everyone. Nayeli Navarro. My pronouns are she, hers. I'm a youth justice advocate from Santa Clara County. I am currently a youth voice coach with the Youth Advisory Council with Fresh Lifelines for Youth, and I'm formerly system involved. And I'll pass it to Matt. Have you gone?
Good morning. My name is Matt Cinco. I am the SSA Staff Service Analyst for FSO, and I am in charge of travel reimbursement, but I will just be manning the timer today. Howie?
Good morning, I'm Howie. I am also a staff services analyst here in the FSO team. And I will be handling the raise hand for the audience on Zoom. We'll go with Lindsay.
Good morning, everyone. My name is Lindsay. I'm the staff service manager here, and I'm also part of the regulation revision team here with Ginger, Amanda, and Allison. I will pass on to Ginger next.
Morning, everyone. This is Ginger Wolf. Thank you for being with us today at our second meeting. I will pass it to Amanda.
Good morning. My name is Amanda Ferreira. I'm the regulations analyst here at BSCC, and I will pass it off to Allison.
Hi, good morning, everybody. Allison Ganter with the Board of State and Community Corrections. And I believe, did we get all of our work group members introduced?
I think so. Yeah.
I think so. I'll pass it back to Kristen, and between Kristen and Forrest and I, we can get us kicked off and then pick up where we left off last week.
Okay, so let's talk about our goals for today. Obviously, we are here to review Article 8, the medical and mental health regulations. And I just wanted to say a little bit about our process. You know, much like we talked about last time, and I want to highlight what Joni said in terms of a collaborative nature of this group. We're here looking for consensus, you know, amongst all of our work group members on any changes that need to be made to the regulations going forward. And I think that it would be, it kind of behooves all of us, you know, that we agree what's reasonable for all facilities, because these regulations are a guide for facilities to develop their own policies and procedures to you know, deliver these services within facilities across the state. That's why they're relatively general in nature, and you know, we're looking at what can be inspected for, and we can't make, you know, really specific things because we don't know what each facility's policies using this as a guide would be. So with that, I'm going to kick it over to Forrest to talk about some of the housekeeping things for today.
Yes, thank you, Kristen. And just to put out a few formalities to get us going here with some housekeeping. When speaking, please be sure your microphone is not muted and speak directly into the microphone, as I was so instructed as we started. For those in person, the green light on your microphone indicates you are not muted. Please remute yourself when you are not speaking. We'll be reminding you throughout, of course. Another reminder, one of the most important lunches from 12 to 1, since that's part of our agenda. We have to stick to that 1 hour time frame. So we will have additional morning breaks throughout as needed. There's no outside.
If you've been the victim of crime,
Was that? Okay. So I won't go into the restroom codes and things of that nature, but just a few notes about Zoom. We've changed how we conduct public meetings on Zoom. We want to ensure that meetings are organized and stay on track, and that members of the community have a fair opportunity to comment. People on Zoom will not be able to unmute themselves during the meeting anymore. The chat feature will only be used by BSCC staff to post messages and links throughout the meeting. If anyone has a question or would like to submit written comment, please email. This is the email regulations@bscc.ca.gov. When public comment begins, commenters will need to use the raise hand feature or dial *9 if attending by phone to join the public comment queue. When called upon to speak, you will be asked to unmute your mic. And those are some of the basics of to get us started here. And I'll also be trying to provide a little assistance in guiding to move us along. So, you know, try not to get us too caught up, not to say rushing through anything, but just to kind of I don't have a timer, but I might kind of like say, let's wrap around and see where we are and how we can move on and come with a consensus, or if we need to pass it on to further discussion with the ESC. So with that, I'd like to pass it back on over to Kristen.
Thanks, Forrest. Allison, did you have anything you wanted to add before we get started?
Yeah, and we'll do public comment again one more time before we begin our meeting. And I just wanted to also, echo some of Kristen's comments about getting started. The purpose of this group is to put together the regulations, revisions to the regulations for ultimately the ESC and board approval. And I know we say it a lot of times, and it is in the interest of collaboration that the regulations don't cover every operation that's in a juvenile detention facility. They're intended to be the framework for the policies and procedures. They are not the actual policies and procedures. And where there's statutes and other community practices in the case of medicine, there may not need to be a regulation. So one of our roles as staff is to guide these regulation revisions through the Office of Administrative Law process. And we have to justify in great length all of the revisions that are made. They need to be operational. They need to be reasonable. They need to be grounded in some practice, research if possible. So we did take a lot of input during this process, and the other uncomfortable thing is that not everything that's been recommended ends up in the regulation. So I do want to acknowledge that the input is invaluable. But again, this group, the purpose of this group is to take all of those comments and then put them through the process of, are they attainable? Are they reasonable? Are they operational? I can't say that word today. Operational. Can a facility do something? Not that a facility couldn't do something. A lot of times we talk about best practices, and in the most perfect world possible, our regulations would mirror best practices. It's not always possible for various reasons. So I was actually talking with Judge Lucero, the director of OICR in the last week or so, and we were having a conversation about where there is discomfort when a best practice doesn't meet the criteria for a regulation. So one of the things that I also want us to be mindful of is if there's a best practice that doesn't fit into regulation, we're going to make sure to pass along some of that information over to OICR as well. That agency is set up to promote best practices. So we had a really good conversation about that. Again, one of the best parts of working on regulations for all these years is the breadth of subject matter expertise that comes into this room, and then coming up with the best possible regulation we can. So again, I just like to remind people about the function of a regulation. Where there's a section elsewhere in regulation, we'll try to guide content into those areas as well. And again, where we can't put something directly into a regulation, we can help pass some of that information over to OICR as well for publication of best practices, things like that. That's all. I just wanted to point that out and see if anybody had any questions from the members before we go into public comment. And then I think we're picking up at 14:07. Okay. Any questions or comments from members before we go over to public comment? Okay.
Allison, I have a quick process question.
Sure.
So today is our goal to get through all of Article 8, and as far as we get is as far as we get. Is that, I'm just trying to set our plan for pacing.
I'm going to be honest with you. This process has not, as a whole regulation revision process, I've not predicted very well. So I really hesitate to make a prediction. It would be fantastic if we could get through all of the revisions as best as possible when we have a concept that we want to see in regulation, as best as possible, if members could say, okay, in that sentence, I'd love to see X, Y, Z, and ABC. And when we have that consensus, we're gonna we'll ask Amanda. She'll have Amanda F. to have the regulation on the screen. The longer we take to get regulations recommended, the longer it will take to get these revisions into the facility. So we certainly don't want to rush the process, but we would be so delighted to have some fantastic revisions to share with the ESC soon. The ESC and the SYTF subcommittees are waiting on these work groups for their next look. I hope that helps. I'm hopeful. That's unfortunately or fortunately my nature. I'm not sure which one today. Dr. Arguello?
Good morning. As we go through these regulations, how much should we take into account the behavioral health transformation, the CalAIM efforts that are taking place that may affect or influence some of these regulations? Is this something that we should be doing now, or this is something that at a later time we're going to have a different review to incorporate these changes that may impact the regulations?
That's a really good question. I'm going to do my best to answer it in a way that makes sense in my head, that hopefully translates to all of you. And I do not know anything, not even enough to be dangerous about the CalAIM process. What I do know is that it is set up wholly separate from these regulations, and that facility administrators, and Kristen can probably help me out here, and healthcare administrators, they must follow and incorporate whatever is required by CalAIM into their facilities. So we can't duplicate something that's in statute, in regulation. We can make reference where appropriate. For instance, I think, and I could be making this up, we've talked about in the past, like during release procedures, making sure that there's connections made with the community. And I maybe think that there was a reference made to CalAIM. But again, if there is an existing process and laws and other regulations, the facility administrator and the healthcare administrator must follow this. We don't have to put them into regulation. So my advice would be, if something, and again, I don't know enough about CalAIM to say very much intelligently, but if there's a place where there's some sort of crossover in something in the regulation, there may be language that's appropriate, but we can walk through those and those specific examples. And Kristen, I don't know if you know, if you can help me with that answer either, or anybody else. I, again, don't know enough.
I think, like you said, Allison, what's happening with CalAIM and the changes to like the managed Medi-Cal plans across the state, I think we have the ability to put a reference, much like, and it's only because it's open on my desk right now, the confidentiality section, we have a reference in there that points to all other applicable state and federal laws, right? So I think that in the sections that it makes sense, then we could put a reference in there that covers, like release procedures like you were saying. But CalAIM is a whole thing in and of itself that we're working on right now, and that we have other, other planning and other stipulations, if you will, about what has to be in place within facilities, and paperwork that has to be done and plans that have to be in place that is really, really specific to what happens, especially around release for youth or anybody from a detention facility going forward.
Amanda, why?
Yeah, I've kind of been having that same question and thought process as well, since we are looking at the 2026 implementation for all correctional facilities within the state of California. where I've been looking at the kind of Medi-Cal / Cal-AIM language will come up in 1437. In some of the in my desire to kind of clean up that section in the language part. And so I think we'll have an opportunity to mirror when appropriate, but like Kristen said, in the confidentiality, it's all applicable statutes, et cetera, et cetera. So it's been on my mind as well. And I think we can, if we do have some questions about how Cal-A might impact it, I think we could probably address them in the sections as applicable. But I don't think we need to get too far off into the weeds about it. And because 2026, when it is implemented, and that's not even to say that the state is not going to, DHCS is not going to push that deadline back farther. So I think in good faith, we'll do this, keeping in mind some of the other language that DHCS uses, like licensed practitioners of the healing arts, to make it consistent. And I think that would probably suffice.
Mm-hmm. Yep, totally agree.
Any other members have questions before we begin our public comment? And so what we'll do exactly the same as last time. We don't have anybody in our office here, so we'll begin taking public comment from people on Zoom. If you could please use the raise your hand feature. If you're on the phone, you can dial *9. And our colleague Howie will add you to the queue. And when it's your turn to speak, Howie will unmute your microphone and we will start a timer for 2 minutes, and we will start that process now. So anyone that'd like to make public comment, please go ahead and raise your hand and Howie will call on you.
First person we have is Colin Ford.
Good morning. My name is Colin Ford, Director of Policy at Fresh Lifelines for Youth. I was sorry to miss the first day of this specific work group, but look forward to listening in today. I'd like to uplift a couple of common themes that youth at FLY have given feedback on over the last couple of years on this issue. First, want to uplift that our youth have repeatedly mentioned that mental health is interconnected with all the title regulation sections, and want to make sure that this work group is considering those interconnected pieces. Food, rooms, beds, sleep, all of these aspects of a young person's day are essential for mental health. They have a cumulative effect. Furthermore, the poor conditions and the violations of the rights of young people also have a cumulative effect, a cumulative detrimental effect on the medical and mental health of youth in facilities. Second, I want to uplift from our youth that there's a serious issue with supporting youth mental health in facilities for a couple of reasons. First, that incarceration is inherently traumatic. Youth cannot get well in a cell. Second, that youth largely do not trust the staff and institutional officers they interact with. And I think this needs to be taken into account. For the regulations you're discussing today, one recommendation from youth is making sure that screenings are done by licensed professionals and not by poorly trained staff. For a couple of reasons. One, qualified professionals should be handling any type of mental health screening, so it's done right. And second, youth have repeatedly said that they don't trust sharing things with staff and institutional officers. And so those won't be accurate reflections of what's going on with young people. Thank you for your time.
We have no more raised hands on Zoom.
Thank you, Howie. Thank you, Colin. So with that, Kristen, we can get started with 1407.
Okay, so I know we spent some time talking about this at the end of our meeting last time. And so I guess the question that I have, I think that the changes, it's up on the screen right now. Where did we leave this? And where do we need to pick up? Are there other changes from any of the recommendations that were in the attachments that we want to see in here? Joni, your hand is up.
My memory of how we left it was I had a lot of things to say at the end of the last meeting, which weren't very organized. And we left it for me to kind of look at between last week and this week. I did email Allison some kind of suggestions. Allison, I did it like 3 minutes before the meeting started.
Oh, thank you.
And
Because I'm like, oh boy,
no, 3
okay.
minutes before, and also after I emailed it, there is a section in there. Let me go back. In between last week and this week, I've consulted with, or I tried to identify like who some of the leading experts were in confidentiality and things like that. So I did was fortunately, together with Meredith, able to consult with somebody who's considered a nationwide expert on this stuff. I've been trying to do some research on it myself. So I just wanted to let the committee know, that this is an exceedingly complicated issue, and I'm trying to get information about it so that we can do this responsibly. My suggestions that I emailed Ellison included a statement of intent, which may not be appropriate in a regulation. And I just want to make it really clear that I sent it before you made those statements at the beginning of this meeting, and I'm trying to be very mindful of how the regulations themselves need to be general. And so I just want you to know I'm not wedded to that. I'm actually, some of that language is taken directly from case law addressing, the importance of the psychotherapeutic relationship in particular. But I will concede, right, that is not in line with kind of what you all spent a lot of time talking about before. So I just want to let you know that.
But may I just it's helpful to talk about the intent. And sometimes we, in these meetings we are, we're moving and we're looking and, we end up coming back to the intent. It's helpful for us to all understand what the intent of the regulation and what the changes are. So this is really helpful. We
Okay.
can't put it in a reg because we can't inspect for intent, but it's helpful for discussion to be able to see it.
Sure. And I actually really want to thank Mr. Ford for his public comment, because I think that does get to kind of the issue, one portion of the issue here. As I said, I'm a defense attorney. I represent youth individually, and on an individual basis, I have to be thinking about what is good for their criminal case and how their criminal case presents in court. That can be in conflict with what a kid's rehabilitative need is. And so I really appreciate, again, I really appreciate being here so that we can talk about this. I think it's important to recognize that when youth, especially youth that are committed to like an SYTF or a post-dispositional long-term custodial program in a juvenile hall facility, that mental health services are going to be really key in making sure that those youth can rehabilitate or access the treatment that they need. But that is really undermined when sensitive information is shared when it is not supposed to be shared, or it is shared in a manner that youth are unaware of, or if it's shared in a manner that's not responsible. And so I think, I took a look at some other counties, the county implementation of 1407, and it just sort of seems to me that, the way that 1407 is worded is just not clear, and the law itself is so complicated. There are issues about, HIPAA and the California Medical Information Act that governs information in the medical setting, and then separately there's evidentiary privilege, right? That has to do, like, even independent of these HIPAA laws and the CMIA and all of that stuff, there's also the issue of privilege and evidence and kind of a whole separate legal scheme that dictates when this information can be shared. It is I can't emphasize, it's very, very complicated. And I think it would behoove us to have some kind of subject matter expert to really weigh in, or to consider, Allison, I don't know if this is possible but to be able to consider maybe like a template or something that might be appropriate to, be able to give to counties or something like that. So kind of with those things in mind, I had tried to address, we can skip over the intent part, but tried to address in A, B, C, D, kind of, separating out information that's shared that would be protected from the mental health provider to the staff or other people who are not, considered health providers. And then the reverse, well, I don't know. I can keep talking. So I don't know if this is a good place for me to stop, and if you want to discuss the intent part, or if everybody should get a chance to read section A and we talk about it, you let me know what you think is best.
Well, I think, no, and I appreciate all the work that, again, we are relying on you all as subject matter experts. And I think we can all agree, and this happens frequently throughout this process, is that you read a reg that you've looked at 275 times before, and you're like, oh yeah, that could be made clearer. And I agree that the current regulation is a little clunky. So I think that what's hard for us is our brains work in the strikeout underline. So I think we can kind of tell what are the new sections, and maybe we can take a look at this, and people can weigh in. I don't see anything that's doesn't, fit all of those criteria. We're trying to make sure that when a facility reads this reg, they know what they need to do to develop their policies and procedures. And theoretically, they should be already set up to be following all the applicable state and federal laws. So I mean, this is a super quick first glance. I don't see any issues with it, and perhaps others want to weigh in. And then what we can do is incorporate whatever makes sense. I'd really like to hear what Kristen and Amanda why think as well. Again, I always like to see, like, oh, that's already in our policy and procedure. Not that it makes it perfect, but we already know that's something that's attainable because agencies are already doing it. I just wanted to address the template thing. We typically don't put forms in our regulations, because that kind of takes away the flexibility of the agency to have their own form. And I know just from my own experience, there are like all different sorts of, ROI and confidentiality forms. So I think I would throw this over to Kristen to see what you think, and then maybe see what others think about this. What may work in a regulation or not.
So I obviously haven't been able to review the whole text of what you got this morning, Allison, but I wanted to just back up a little bit and remind everyone of what we talked about last time in terms of Allison's guidance around non-duplicative information in multiple regulations. So if there's a better place for some information to go in another section where it's more applicable, we should, be mindful of that. So I would like to have a chance to review what's in here, because again, getting too specific may make it difficult for all counties to build on, right? Just understanding the differences between the facilities. So I think if there's a recommendation to include all of this language, we should all have an opportunity to review it more closely so that we can weigh in on it and be more familiar with it, because it's hard to see it all right here.
Hold on, we're staff consulting across the tables, which is why you see us looking. So if you want to just, I'm gonna just talk with my colleague just for a second, if you all want to continue talking about that.
Amanda, why did you want to add anything?
Well, I think what you're talking about, the non-duplication thing, and it's hard for me as an embedded mental health provider to, I think, separate out what our policies and procedures and how we operate, to understand that not everybody does it that way, and the care that we take to obtain releases of information. Anytime we get any requests from, let's say, like the district attorney to get mental health information, we're referring, we're speaking with the client directly to see if they want to get a release, to submit a release of information for us to disclose any kind of information. So that's the world that I live in. And I did share that some information, but what I realized after the fact was that it was from 2010. So while this original spirit and an intention of some of the information sharing of, covered entities versus, who's covered by HIPAA and who's not, and historically correctional facilities have not been covered by HIPAA, and I don't know if the laws have changed in relationship to that, again, because the reference material that I was looking at was old. So so on its surface, I think what we're really talking about is, are we creating regulations that then require the facilities to adhere to HIPAA and all of those standards? Because I think that that's part of what Joni has indicated in here, that information sharing agreements, and with CalAIM, obviously that's coming, because that's a big part of how do you coordinate mental health, substance use into a release plan, without having some sort of agreement or ability to share information. Fortunately, most of our youth really do sign releases of information to be able to share information. But I realized that not, like Matt was saying earlier, not all youth feel comfortable in how that information would be used. So we do a lot of informed consent. So that's more context, I think, of where I'm coming from in this whole entire section, where it's challenging for me to understand how why don't other people in places do it like we do. So
Well, and I can appreciate that, Amanda, because I similarly, as I look at these, I think about, the role I have within the facility that I work in, and I have both sides of it. So I have medical and mental health in my section. And I think you raise a good point. I mean, we have these guides in terms of confidentiality laws that I am intimately familiar with because I have to be, right? But I'm also aware of information that the kids control. And we have to get those ROIs signed, and we have to be able to continue to provide confidential treatment in a way that's going to be meaningful to the youth. And sometimes what that means is that the youth isn't comfortable sharing information in a certain format, and we're aware of that. So we have the ability to not just work with the youth, work with our probation partners, but also understanding provider to provider relationships too, in terms of other providers that we're doing a warm handoff to, for instance, in the community when we're transferring care, whether it's medical or mental health. The other thing I wanted to highlight for this section is that this covers all confidentiality. So it covers all health related confidentiality, whether it's mental health, substance use, medical. So keeping in mind that, you know, everything that goes into this section is intended to cover the confidentiality of what the medical and mental health staff are providing for that youth within the facility, right? And sometimes, you know, we're on site. So I don't know how it's done in some other facilities in terms of which providers are actually doing this work, whether it's telehealth and they're not on site or what. So I feel like I'm rambling a little bit, but I hope that makes sense. So where do we want to go with this? Do we want to pause again on this one and come back to it, or?
Well, if this works, so what might be helpful is to, we'll take some time to combine the suggestions that Joni made into a cleaner version of the regulation, and hopefully by lunchtime or a break, provide that to you all, and then we can come back and maybe seeing the changes on the screen, we can go kind of section by section and see if it makes sense, and perhaps everybody will have had a chance to think about it and process a little bit more, and then we can see where we're at there. It'll just take us a little bit of coordinating, like I can't get my screens to cooperate, so we need to just do some editing to put the two documents together and strike out underline. But if that works, that's what we can do.
Okay. So do we want to move on to 1408 then?
Does that sound okay with the rest of the group? If there's no opposition, maybe let us know if you disagree and we can come back. But if there's no opposition to that, we can just move on to 1408 and come back to 1407.
I just want to make sure, are we going to get the draft before lunch? So I just want some time to
We're
look
gonna
at
do
it.
we're gonna do our best. We're all on sort of portable, tiny weirdo screens. So I hate to blame technology, but we're gonna do our best to put the documents together and then get that to you as soon as possible. It's just as soon as we can.
Okay, so no, are there any other comments before we move on? No? Okay. So let's look at 1408, transfer of healthcare summary and records. Looks like the reference below is changing. Are there any comments, questions, concerns around this section? And any of the suggestions in attachment B that we want to highlight? Meredith? Wait a minute.
I was thinking, looking at C, subsection C, around notification to the receiving facility. The one sort of issue listed there is communicable diseases, which seems important. Seemed to me that there are additional things that a receiving facility would want to know immediately. So I was going to suggest health, something that adds other health conditions, including but not limited to suicidal tendencies in accordance with section 1329, where there's reference to gathering that information, ongoing medical prescriptions, or health conditions that might require, immediate intervention and continuous care. So I know that was a lot. I realized, Allison, I don't know if it's helpful to like put language in the chat so that Amanda can see it as we're suggesting, or let me know what the easiest way to do to like give language is.
So are you suggesting like those specific, like really specific things? Because in A, it says a summary of the health record or documentation that no record exists, relevant health records. And I think the reason it's calling out communicable diseases specifically is because we would worry about if that wasn't shared, then, the potential for an outbreak in another facility. And I'm specifically thinking of COVID right now, just because we've lived through that for so long. But I feel like if there's, like what you just said, because I agree, like this not limited to might be better in like A, right?
I think I'm trying to pinpoint some of the things like you're talking about, like COVID, something that shouldn't require someone to go through the healthcare record summaries, something that they should know immediately. And I would actually look to Dr. Bernard if there are things that she might think of that, you want to know from the jump without having to turn a page. So I think, risk of suicide, heightened suicide risk, for example, or, serious medical issues that if they're not known about, I don't know, maybe epilepsy, something that like ought to be known without having to review summaries. Just the way that, having COVID would trigger an emergency if people didn't know about it the moment that the youth is transferred. So I'll just, I'll put what I'm thinking of in the chat. The only other thing is in line with the edit to the last sections, when we reference confidentiality, I do think it makes sense to reference like all applicable state and federal laws so that it's not narrowly to like confidentiality is defined, in the regs.
Yeah, putting it in the chat is helpful, and then Amanda can show once we have a sense that that's kind of the words that we want to see. Amanda can pop those up into the document, and we can see how they look. Melinda, you had your hand up?
Through one of the things we have been trying to work with corrections agencies about is recognizing that youth have disabilities that affect their behavior, behavioral disabilities that will be reflected in their health records, such as ADD or schizophrenia, that require accommodations by custody staff. And some of these might be repeating instructions or giving youth a time to sort of leave a situation as opposed to requiring them to comply with orders. So those are typical accommodations that we negotiate for youth. And I'd like to have added to here disability status and any accommodations needed. In Joni's draft, we had some language to that effect about disclosing information to the extent needed to determine accommodations. And so the disability would be reflected in the healthcare record, and but the accommodations would be important for custody staff to know from the get-go, because even at intake, you may need an accommodation to respond to orders.
Can I just ask a clarifying question about that? So again, this section is wholly about transferring those records. And so the disability and reasonable accommodations, those sorts of things, I assume would be in the summary of healthcare record. What I'm curious about is that there might be another regulation that operationalizes that youth's needs and how they're accommodated. So I just want to be careful not to pack that into this regulation, because again, my assumption, and I could be wrong, is that there are going to be other things that would also, like, we want to be very careful about not listing out everything that needs to be in there if it's covered somewhere else. Please help me out, Kristen.
So I think that what you're talking about, also 1413 is individualized treatment plans. So that section, but I also want to highlight that the purpose of this section is the transfer of healthcare summaries to other healthcare staff within the facility. 100% agree with you, Melinda, that the information around accommodations that a youth might need while they're on site, in order to just, be successful in the milieu of the facility would be important for the facility's healthcare staff that receives that information to be able to share. But this section is specifically just in terms of the transferring of that record to share the information with the incoming healthcare staff, right? So yeah.
That sounds great.
Just to clarify, Kristen, this is talking about transfer between facilities, not within a facility, right? So you have a child unknown to
I
a
was
new
muted.
facility, coming in and arriving as a complete blank slate to that facility. That's why I'm concerned about C, that I think there are things medical providers would want to know about a child that they're just meeting like immediately.
Totally agree. And I think what I've seen, and of course, much like Amanda and I both just alluded to, we do things a certain way and we have our policies in place, but I think, most facilities have what's called a discharge summary that lists out much of this and then additional records are attached. So I think 100% just my opinion to call out specific things here that, we want to highlight is totally appropriate. But just keeping in mind that this information is intended to go directly to other receiving healthcare staff and not necessarily the probation staff within the facility.
I've copied Meredith's recommendations from the chat onto the screen. And Dr. Barnard, I do see your follow-up comment in the chat, but I'm a little confused on, did you have a follow-up on Meredith's comments? If you can give me a little bit more clarification, I'd appreciate it. Maybe she stepped away for a moment. But I have Meredith's recommendations copied on subsection C and E.
Nothing further on the approval agenda for my colleagues.
Also included a comment here, and this was Liz's response to Meredith's comment.
Is there any feedback on the recommendations that are on the screen?
This is Amanda. I like the addition that it is again just not limited to communicable diseases. Again, the facility will create a transfer packet that does make its way around through the medical and to go with the youth at the time, either prior to or at the time. I know in the chat there was some consideration of moving that to section A. But I think that may be some duplications or redundancies, unless we were going to take it out of C and put it totally in A. I think as long as it's in there, it's still covered under the entirety of 1408.
Yeah, and I think it's succinct enough that I think it's fine. Anybody else? Forrest, were you saying something?
Yeah, I was just saying if there's no other comments or suggestions, or if everyone is in agreement with where we are, we can move on to 1408.5, which is so if everyone's okay with that, we'll move on to 1408.5, release of healthcare record summary and records.
Dr. Arguello?
Yes, thank you. When I review this section, one thing that that came to mind, is that is requiring that upon request, the information is transferred. I think it's important that whenever possible through the transition period, if it is known that the youth has an appointment with a specific provider, that those records are transferred as soon as possible and not to wait until the youth has been released from the facility. So I wanted to see if we can look at language that may include that. And then the other thing that I saw and actually, made me think was that they were going to provide non-confidential information on medication and other treatments orders prior, okay, or at the time of transfer for some facilities. Well, these are all kind of confidential in nature. So we would, do that also with getting consent to do that. And so the non-confidential information, I don't know what that could be, okay, at least in my view. So those are the two things that really, raise some concerns about this section. Thank you.
Amanda?
My suggestion would be, I agree. After release is very too vague. To be current with someone who might have an emergent condition. So I would recommend prior to or at the time of release. something along those lines of um, what's standard with best practice and coordination of care. And then I also agree with the doctor about the the language and non-confidential information regarding medications. HIPAA can be suspended for purposes of care coordination. But again, do we want to delve off into those conversations of confidentiality as it is in what 1407?
Did you? Okay, I can't see it. I'm like.
So I'm not sure if there's any other comments. Amanda, do you have? We can circle around and make sure you have what you need if that would be it.
So whatever works for this group. Having done a couple of these work groups, I've been instructed to not make revisions on screen until told to do so. So I've been putting some of these in comments on the margins. I've had other work groups want to see those revisions taking place in real time. So really, if this work group prefers to see it one way or another, let me know. I can start making these revisions in real time as you're speaking, and you can correct me if I mistype. Or I can wait until Kristen or Allison or Forrest gives me a directive to add text specifically for you to view.
Sorry, and Kristen had to step away for a minute. Why don't we add in the prior to? Prior to when? Add a when in there. And I see that was there and I'm sorry, I was multitasking over there, so I wasn't quite plugged in. Perhaps the person that recommended the non-confidential unclear, is there a recommendation to define that or change the term?
Yes, I think that we should, better define what we need. We can just say information. I mean, do we have to add the non-confidential information and then let the staff and the facility deal with whatever confidentiality is there for that information? Does that work?
Yeah. Dr. Barnard, you have your hand up?
Hi, yeah, I had my hand up. I'm sorry, I had to take a call from the American Pediatric Society president, but in A, there were questions about the language that I proposed. If you'd like me to give input on that, I'd be happy to. Sorry, I missed that.
Oh, on 1408? Oh, okay.
Yeah, where we were before.
Can we come back to that after we finish 1408.5?
Sure,
That
anytime.
would be really helpful. Meredith?
Yeah.
I was just going to say, I like the edits that have been proposed, and I share Dr. Aguayo's concern about, not relying on youth to be proactively planning. So I was going to suggest that we, because this section does address like this prior planning and authorization, that we add some language referencing, as part of planning, as outlined in 1351, which is the release planning section, healthcare staff shall work with the youth to get all authorizations signed in order for youth to access continuous care and treatment upon release. Something that gets to this concern about making sure this proactive planning is happening and promoting continuous care. So I'll put a suggested sentence in the chat.
I do want to add in response to Meredith's comment, I do know in section 1351, not knowing the language off the top of my head, but there was a similar recommendation to include cross-references to not only medical and mental health sections, but, you know, dentistry, education after release, references to other sections that were important in that release planning section. So this may be one of those where it belongs better in 1351 and then refer to all of these other sections rather than including a reference back to 1351 in all of these sections. Just something to consider. And back to Dr. Arguello's original question is what's considered non-confidential information in regards to medication and treatment orders?
Meredith, your comments for up to prior to when, correct?
My comment is to add that sentence after the period, parent/guardian period, then add that sentence.
Okay, we got a little turned around because we were doing the non-confidential one, then we came back up to there. So we'll plunk that in there. And then can we go back to, I'm not clear on the non-confidential, what needs to change there. I don't know if we had a specific recommendation for language.
My initial recommendation was just to remove non-confidential out, and that way, whatever process needs to be followed, okay, for any confidential, if any of that is confidential, then can be followed by the staff and the providers.
Well, I think so this section, and this section is very specific to special purpose juvenile halls, other facilities that don't have on-site healthcare staff, that the youth supervision staff are responsible for forwarding any information. I don't know how that works. We have three special purpose juvenile halls left here in the state. So that section wouldn't apply to facilities that have on-site healthcare staff. I don't know if that changes the nature of the recommendation. Again, I also don't even know what agencies don't have on-site healthcare staff. So again, just think about if there were a type of facility that didn't have on-site healthcare staff, which might be one of our special purpose juvenile halls, the regulation would require the youth supervision staff to forward any of that information. I don't know if that changes anything for anybody. It really does cover a small subset. It wouldn't apply to our typical juvenile halls and camps and SYTFs. Does that change anything, Dr. I'm so sorry,
Great.
Dr. Arguello.
Not to me, but I would like to hear from other members.
And Kristen had to step out for a moment, so hopefully she'll be able to weigh in on that as well.
Part of how it could be interpreted is that you're just telling, like, the detention staff is just telling the other provider that the youth have been in treatment, you know, medical or mental health, been receiving these types of services here. So then there's not it, so that again is kind of covered under the it's not exactly a provider to provider again, but it's in the spirit of coordination of care without a large disclosure of the confidential nature of medications or diagnoses, those types of things. It's mostly just an alert, because I don't know, until Allison pointed it out again, what a special purpose juvenile hall or facility is. And again, so
oh, go ahead.
no, I don't particularly have an issue with that section, and I'm okay with taking out the non-confidential part, but it's really just they'll provide information for coordination of care. I mean, I think that's really the part of it. And what is the special purpose?
So special purpose juvenile halls are, Forrest, I think there's 3, 'cause don't you have one of them? I think there's only 3 left in the state. They are facilities. They are not full service juvenile detention facilities. They are only authorized to hold young people for up to 96 hours. I believe there's one in Mariposa. They're more intended as a booking type place for young people if there's a need for them to be in a juvenile detention facility before they would be either released or transferred somewhere else. Inyo County has one, and I don't think they've even held a young person in there for a long time. Trinity, I think, has one. They are not, they're not something that's all across the state. And I see you have your hand up, Joni, but I just wanted to, and I was going to ask Amanda just to highlight that other facilities that do not have on-site healthcare. Again, I don't even know that there is such a facility out there. So I want to be clear that this second section wouldn't apply to an agency that had on-site healthcare in the building. Joni?
Thanks, Allison. I'd actually lowered it and then raised it again, so it wasn't like an attempt to get attention. I just rethought. I kind of think again, this goes back to confidentiality and information and kind of how it's stored and how it's communicated, when it's disclosed, when it's redisclosed, what's confidential. Like that is a very complicated area, and I think we need to spend a lot more time on it.
I apologize that I had to step away. Today is a practice in how to be in 2 places at the same time for me, and hopefully I won't have to do that again. So my apologies for not being able to participate in the full scope of this. I'm reviewing the language that's there right now, and it concerns me a little bit to put into a regulation like this a statement that says healthcare staff shall work with the youth to get all authorizations signed. Because I don't know that, I mean, obviously, we want to have ROIs signed for the ability to share information in the best interests of the youth, but we certainly can't force their hand at that. And I think it's important for people to realize the nature of this section talks about releasing records to other healthcare professionals. So when we're talking about, medical treatments such as medications that are prescribed or ongoing treatment that is needed for that youth, provider to provider release of records is allowed. And so, you know, there may be certain aspects of the record, specifically like, you know, using mental health as an example, psychotherapy notes may not be something that would be readily released, but medication records in terms of a psychotropic medication that a youth is taking that they intend to continue taking, we want to link them to care for that, right? So being able to release the records and the history of the medication used by that youth would be allowed provider to provider. So again, I would be hesitant to put it into regulation or agree to a statement that seems to point to healthcare staff being mandated to have a youth sign a release that they're not in agreement to sign. And I apologize, this may have been covered.
No, that's not the intent. So if you have a better way to word it, this was just a suggestion. The intent is not to like force a youth's hand, but more that there's like a collaborative effort so that youth can maintain their care upon release. So maybe shall work with the youth to complete authorizations as needed. Or, you know, Dr. Arguello talked about, you know, not wanting to put all the onus on the youth to request things. So just trying to get to that point of like, you know, a 15-year-old doesn't necessarily know what's needed. They know that they want to, you know, keep getting the treatment that they've started.
Well, and this is one of the areas, you know, we were talking about CalAIM earlier, and this is one of the areas that specifically when we think about like pre-release planning, for instance, around healthcare that's needed, whether it's mental health, dental health, or medical care, this is something that facilities are now being mandated on another way to pay attention to and to have plans in place for. So, you know, the continuity of care obviously is dependent on proper records being shared amongst providers, right? And linkages to care is something that CalAIM really focuses on. So I wonder if this would be an appropriate place to mention something to the effect, you know, release of healthcare records, community health record information shall be promptly transmitted to healthcare facilities in the community upon request and when written on the parent guardian. You know, some mention of CalAIM requirements, and I'm not exactly sure how to word that.
Can I jump in really quickly?
Mm-hmm.
So, you know, I reread this regulation, and again, this happens a lot. The reason why it says after youth are released to the community is because if you read the regulation, so there may be another appropriate place for some automatic transfer of records. And I don't know if everybody's reading this the right way. And I read it backwards, of course. After youth are released to the community, healthcare record information promptly transmitted upon request. So I don't like, for me, this changes because this is something that would have to be with the written authorization of the youth and or parent or guardian. So I think this isn't like an automatic transfer. This is something, and this could be prior to, but I just wanted to make sure that we all understand that this is something that would be generated by the young person or their parent or guardian. I don't know if that changes anything. I was not reading it that way when we were talking about it, but I am now. So I just wanted to make sure everybody is on the same page as me, and maybe I was the only one reading it that way.
Thank you, Allison, for pointing that out, because you're right. That does change it a little bit because, you know, when we get a request for records from a youth or, you know,
Sorry.
another medical office. Typically that is going to include really specifically what they're looking for and what they need and why they need it, kind of thing. And it's always going to be continuity of care or follow-up for like a health condition. So it changes it, right? If you add the language prior to, because then we're not addressing what happens if we get a request for records from another office. Dr. Aguayo, did you have another comment?
Yeah, I was gonna say, make two recommendations. The first one is to separate it so that it is clear that when they obtain a release of information, okay, from an outside provider, that is done, very, very quickly. And then talk about if it's known that the youth is going to receive, services within a specific provider or agency prior to the release through the transition period, then that information is then shared with the known provider prior to discharge. Then the other thing that I'm thinking about is you mentioned that of course we can share information provider to provider. Should we then put that in here, okay, so that happens if we really want that information to be shared and take place? So I think those are things that I'm thinking about, that you're right. We may need to separate, after the youth is discharged and then they go and they see a provider and the provider needs information about what took place, within, the facility, then that, response should be quickly, okay? And I think that that's part of the intent. And then what happens if it's known way prior to discharge or during the discharge process that they're going to go see somebody in the outside, and that has been set up, that appointment has been set up by facility staff or staff, or providers that are taking care of the youth within the facility. So that information should be transferred, prior to the youth. So it's not delayed by waiting for the youth to be discharged. Am I making, am I
Yeah,
clear?
no,
Okay.
I understand what you're saying. Yeah, and I think something to keep in mind too, and again, just from my own experience in doing this, when we're establishing appointments for youth, while they're still in custody or while they're still in the facility, whether it's to establish care when they leave or, it's specialty care that maybe isn't provided on site. Just like any doctor's office that would be making a referral to another doctor's office, we're including information about why we're sending them, right? So the receiving physician or healthcare provider is aware of why the youth is coming. So anything that's pre-release, CalAIM is covering like what, pre-release services that need to be provided in the interest of continuity of care. If the youth leaves and approaches, 6 months later or a year later, and to Allison's point, I get that that's what the goal was with this, that if there's a request for records from an outside provider for something that may be on site, or maybe happened on site, those records need to be transferred right away. There shouldn't be any delay with that happening. So I think that's two separate things. Pre-release, planning and establishing care somewhere versus a really specific request from a youth or a parent to transfer to a provider somewhere else, right? Because I think if we can a hypothetical situation could be they went to a different community that maybe we didn't send the records there because that wasn't part of the pre-release planning, right? So.
And that was my point, to separate it into those two scenarios.
Amanda F is gonna, she has a couple questions and comments for us, and then Meredith, I see that you have your hand up as well.
So I'm gonna pop up a different screen just showing our existing regulations because I want people to consider the other section 1351 where this may fit. EC 1351D, notification to the facility healthcare provider in accordance with section 1408 and 1437. If 1408.5 is significant enough to call out for their release period, maybe it's better sat here, 1408, 1408.5, and 1437 for coordination with outside agencies. That way 1408.5 doesn't become unclear. Just another consideration to make. I know it's not in our materials, but this is where I personally think it would belong if it's worth calling out this section specifically.
Yeah, the only issue I see with that, Amanda, is that 1437 only deals with mental health. And I think that the release of the healthcare, it's bigger, it's more than just the mental health aspect of it. Like when we're talking about, especially establishing care. I guess I don't see.
1408 is transfer of healthcare summary and records, but I see 1437 is specific to mental health. So I was
Right.
just curious if 1408 is that significant to call out amongst all of these 1400 sections, this is where I think it would happen. When it's specifically to what happens for release. But there may be a need for a cross-reference between the two. I'm not sure, but this is where I keep going back and forth between the two sections. I think people are saying the same sort of things.
Yeah, I think to Dr. Arguello's point though, I don't see why in 1408.5 we couldn't have mention of both, like after youth are released and then prior to release, right? The transfer of records. I think the prior to release, it would be important to mention just, Calium and the continuity of care aspect of it to establish services once the youth is released. Because they are different. There's different reasons behind that, right?
Would there ever be an issue where if you're preparing everything, you know that you're transferring a youth somewhere specific and something changes at the last minute and those records are transferred? Is there any issue there? If because you did it before the transfer took place and maybe, something happened, the kid had to be 5150'd or something happened in the meantime where they're not moving to where the plan was to move them. And now all of those records are released because it was done prior to the release. Would that present any issue in terms of
Do you mean if
confidentiality or anything else?
do you mean if there was a plan for a youth to be established with a specific provider and then something happened in the 11th hour and they weren't established with that provider?
Yes.
That's a great question. I don't know. Because I can't think of a scenario where that would, I don't know.
Oh. I feel thoroughly confused right now. I have a couple thoughts after looking at 3 different regulations. Meredith, do you want to make your comment? And I kind of want to almost hear Meredith's comment and then come back to some sort of order because I'm hearing some really different things. Meredith?
Sure. I just to address the question about 1351, I don't see any problem with referencing 1408.5 there, but there's not much in that section. I think here seems to be where the guidance and standards live. I agree with what I think Dr. Aguayo and Kristen are saying is there are 2 separate issues here and they both need to be addressed pre-release and sort of post-release or upon release kind of planning. And it sounds like it's very important to align this with CalAIM, but that we're not really well equipped in this moment to draft those red lines because the complexity there. So that's my suggestion might be that we need to set a purpose of having something that addresses these 2 different topics because there are 2 contexts in which you're releasing records, and then we need to additionally make sure it's aligned with CalAIM. My last comment is I think Kristen, let me know if I misunderstood your comment, but I thought I heard you say that you don't need written authorization for transmitting information to another provider. And in that case, I'm concerned that this written authorization then becomes a barrier for a youth who's been released. For example, like,
there's a fear of
so
imagination.
I think this has come up
and
in other
prioritizing
conversations.
the
A youth is released, they end up in another county and they need information sent. If there's a written authorization that needs like a wet signature or something like that, that would be a huge barrier to getting the information transferred. So now I'm kind of just zeroing in on this required written authorization and how we can make continuity of care just as easy as possible for youth and their parents to coordinate after they've been released.
I don't know if it's a good time to take a break and come back to that, or if any other members have comments on what we've discussed. I am thinking about this in a very different way when we started looking at this regulation.
process.
So I'll see if there's any other comments to add on to that for right now. And I think it would be helpful to take 10-15 minute break and then we can pick this back up, and maybe what would be helpful is to kind of re-summarize sort of the thoughts on pre-release planning versus the mechanics of transferring records and how you actually do that and when. That's how I'm seeing these issues sort of intertwined, but also how to pull them apart. Break? I hear break.
I agree.
10 minutes, is that good for people?
Sure.
It is 10:40, so we'll come back at 10:50. Thank you.
Sorry about that, everyone. We are back.
Can our work group members hear me? Okay. Oh, yay, that's great. We lost our audio and we don't have video in the room. We have our individual cameras on, but we don't have the video in the room just yet. Oh, look at that. There's nobody there. It's a ghostly meeting. Oh, there we are. We're here. Kristen, I think, oh, there she is. Hi, Kristen. I'm gonna attempt to make a general statement about where I think this discussion in particular should go. And moving forward, what I'm gonna try to do, or what we'll try to do here collectively as BSCC staff is when we get to each regulation, like take a beat, and make just a general comment about the intent and purpose of a particular regulation, because I think one of what I did was read this backwards. So this is just my thoughts on the issues that we're talking about. So when I read 1408.5, really specifically focusing on that upon request, and then again, the current regulation where it says after youth are released, this regulation is really specific about the mechanics of transferring records when a kid's released and wants their records so they can go to another doctor. I make a comparison to if I were seeing one provider and I wanted to go see another provider, I'm the only, like nobody else but me, or if I were a minor, my parent or guardian would know who to send those records to. So when I read this regulation, the agency, it has to have policies and procedures. So when somebody says, I want my records because I'm going to go see somebody in the community, the agency can then say, these are the steps that you have to follow. And certainly that should include, release of information, authorizations, all those sorts of things. But I think where there absolutely needs to be conversation separate from this is the pre-release planning. So pre-release planning, as we showed in section 1351, is what facility staff, how they need to coordinate and plan for a young person's release. And section 1413 that we haven't gotten to yet is specific to the healthcare administrator and how to do pre-release planning for young people, obviously for continuity of care. But coming back to 1405, I really want us to focus on the fact that this regulation doesn't have anything to do with pre-release planning. It is the facility having a very specific process in place. So when a young person or their parent or their guardian wants those records sent to Dr. Smith in the community, the facility has a policy and a process in place. There should be no questions about that. And then I think what we should do is hold off on the pre-release planning and what goes into that until either we get to section 1413, or maybe there is, a need for a different type of regulation. That's my recommendation for moving on. I don't want anybody to think that I'm saying, don't talk about pre-release planning, because that is such an important part of what needs to be in regs, and certainly coordination with the Cal AIM efforts. But so my recommendation, again, just to summarize, is that we focus on 1408.5 as the mechanics for a young person or their parents to release their records to a physician in the community after they're released. Dr. Arguello?
Yes, then my recommendation would be to make this section title maybe more clear, so that when somebody's looking at the regulations, they know that this is specifically after the youth has been discharged, is receiving community services, and then at that point there may be a request for release of medical information that was received while they were in the facility. Because right now, I mean, the way that I read it, I mean, and I started this conversation was, it was difficult, okay, because of the language and also the title. So, so maybe we could consider that.
What about, so Amanda, could you type in the title, try this on for size, and that's a great suggestion. Request for release of healthcare summary and records, and then after records, after release. And then my recommendation would be to delete the prior to when and replace that after. Again, not that we're not going to talk about the pre-release planning, but this is, again, directing the facility administrator to have that process in place. So when the kid's released, they can transfer their records. Yes, please. Thank you, Amanda. And then I don't think that we need to reference 1351 in here. Definitely open to that conversation. Because it's also contained in section 1413, very specifically to the healthcare administration. You know, this general section is healthcare administration. So my recommendation would be to take out that that recommended language, and maybe we can hang on to it, and it's going to be you're talking about, we're talking about pre-release planning, and then separately as the whatever authorizations the young people would need to sign if they, want to transfer those records. I wouldn't put that here. And I'll just pause there. And Dr. Arguello, do you still have your hand up, or was that
No, just one minor thing. If we could in the title take out the first release, because we have to release, so request for healthcare summary and records after release. So that way we don't have two releases in the title.
You're speaking to my English major heart. Thank you. So I would ask the group if there's any opposition to changing the name to request for healthcare summary and records after release. And then taking out that section and hanging on to it when we get to sections on pre-release planning, and then going back into this regulation and seeing if there's any recommendations for revision based on the new title.
I think I would just add in the title, Allison, request for transfer of healthcare summary records after release.
Awesome. And again, how it would work in a facility, again, I don't know if there is such a facility. If they didn't have on-site healthcare staff, obviously if they were taking medication, the facility staff would have to be aware of that. Again, I don't know how that would work. But those types of facilities would have to have a procedure or a policy for transferring that information to whomever the young person or their family chose for care.
Well, keep in mind though, this is health record information, so facility staff wouldn't have specific health record information, but I would imagine, given the regulation and what can be inspected for here, is that they would have something in policy that points to whoever their outside provider is, being sure that there's a mechanism for this to occur, right?
Yes. Meredith?
I'm gonna put some language into the chat that just further narrows the purpose, because I hear what you're saying, Allison. You're trying to focus this on requests received from youth who are now in the community. So I just think that the language that I'm putting here is better getting to that very specific situation.
Would
I'm
you
gonna,
recommend, Meredith, would you recommend replacing that whole first paragraph with the language that you're recommending?
yes, it's a red line. It's pretty similar. I just couldn't get red line into the chat, so that's why it's harder to see what's
So maybe
changing,
I
but yes.
can, okay, so I'm just trying to think, when a request, so the language is when a request is received for transfer, oh, there's Amanda's got it. After they receive community healthcare information shall be promptly transmitted to specific physicians or healthcare facilities in the community upon request. So it's adding when a request is received for transfer of health care record information from a youth after release to the community. And I'm comfortable just replacing it. It's a lot easier. Although yeah, Amanda's got it. When a request is received for transfer of health record information from a youth after release, I'm just gonna trim. After release to the community.
I do want to say though that it does have this like, it states a requirement that there has to be written authorization of the youth. In other words, this regulation is dictating to some extent how the process should work. I think we haven't spent the time to align this with the requirements now under CalAIM. For example, CalAIM requires a post-release enhanced care management lead manager that's working with the youth to coordinate records and info. So I'm just a little worried that even for the narrow thing you're trying to address here, accessing and transferring health information for a youth who's already in the community, even that is addressed in the new CalAIM requirements with, named roles, et cetera. So I think this document needs to be thoroughly reviewed, and we have to make sure that this regulation is not proposing a different and lower standard than what CalAIM is requiring.
So to that point, Meredith, I want to add to that I think it, definitely as a resource to, include a mention of CalAIM here, but my guess is that ECM, so the enhanced care management is much more broad than just healthcare, right? It includes things like housing and other aspects of a person's life and needs. So in most situations, I don't think the providers of ECM will be on site within the facilities because, for instance, when we establish a youth with providers in the community during the pre-release planning phase, we're linking them in most cases to a federally qualified health center who will have navigators on site to provide the ECM for them in an ongoing way. So while again, I think it would, be important where we can to point to CalAIM and the requirements of that, I think we need to be careful to not get locked into something that isn't reasonable under the regulations of Title 15. Does that make sense?
I hear what you're saying, and I am concerned that there are requirements under CalAIM that are not just related to the external care providers, but the in-custody care providers as well. And that's where I think we need to make sure there's alignment.
Of course. And there are absolutely things that, especially when we're talking about the pre-release planning and the continuity of care for when youth leave, that facilities are definitely responsible for. But when it gets into the realm of ECM and the ongoing nature of CalAIM in the community, that's where the warm handoff is really important from facility to the outside. Dr. Arguello?
Yes, it is my understanding that with the Cali Justice Involved initiative, that the pre-release a case management is the responsibility of probation. They can either provide it or they can contract for these services to be provided, by an outside agency, a community-based organization, but that they have to have the same requirements that an ECM provider would have in a health facility in the community. So they would have to start a plan. Okay, they would have to link the youth to the services, in the community, and provide that one hand off and make the referrals to county behavioral health if they're specialized mental health services, or to make sure that they have an appointment, through the managed care, that provides for the youth upon release. So there, all those requirements, okay, are in the Justice Involved pre-release section of the Justice Involved initiative.
Right.
So, so I just I want to make that clear that, yeah, that those requirements are there. Now, in the community, they're able to maybe provide a more extensive services because they can link them to community-based services also as part of Calais. Okay, and if you have the same coordinator, pre-release and post-release, they need to do all of this, themselves. So I just want to make that clarification. Okay, thank you.
Amanda, was your hand up or was I imagining that?
It was, because I think I think each county has some, the ability to kind of choose how they're gonna model, like, so some counties are going to use their managed care plan, to do the enhanced care management. And so this is why counties are going to be having to have information sharing agreements, et cetera, with all of these players and entities. And this is where it gets so convoluted. Take Title 15 out of it. So I think this is part of why it's so difficult, not only to, project what's going to happen and what's going to be required, but I think we all have a pretty good sense, from what I'm hearing of the basic requirements of pre-release, post-release, who's supposed to do what. And for 30 days post-release, the ECM is supposed to follow it, and to ensure that youth are receiving the services that they need. So that was just basically my comment.
Dr. Arguello?
Yes, just to make everything even more confusing. Okay, so services, the pre-release services are paid for fee for service. And then the ECM in the community most likely is going to be through managed care. That 30 days will continue, okay, until the youth can be provided ECM services for 12 months, by the a managed care plan. So, yeah, and they still haven't really communicated how this is going to happen. The last time I talked to Department of Health Services, the expectation is that upon release, the youth is already going to be not only enrolled, but enrolled in a managed care plan. But if they are providing fee-for-service for the pre-release, that will continue for 30 days after, until they can, be changed into the managed care plan. So again, there's so much, and so much detail that is extremely confusing with this, but we just have to do the best that we can. Thank you.
Right, and I think one thing to just keep in mind with
sorry,
this
Kristen,
is
go ahead.
that, sorry. you know, Title 15 doesn't necessarily, like the two don't necessarily cross over, right? The regulations that we're putting in place here and what we come to consensus on in terms of what needs to be reflected that facilities are responsible for, like releasing health records when a youth is released by their request. Again, a mention of CalAIM within certain sections would be useful to counties as they're coming up with their policies and procedures and to guide their own process, right? But the two are, you know, not necessarily intersecting at all times. So while we all know that we are in the midst of all of this planning around CalAIM, I think it's important to keep in mind what we're trying to accomplish with these regulations, which is making them more clear and user friendly, if you will, for those people working within the facilities and directly with the youth. Does that make sense? Yeah. Okay. So if we go back to the changes that were made here to 1408.5 in the title and in the first part of this, is there anything else by way of comment that anyone or suggestion that anyone wants to make to 1408.5? Meredith?
I'm realizing, so I put into the chat the link to the operations guide for CalAIM in facilities. I'm realizing that that's not visible to the public. So I just want to read that that might be a problem, but I know a lot of what's going into the chat is ending up in the document. So my request would be that my comment that we need to not conflict and to meet the floor of those requirements, that has to be considered. And I don't think anybody here has those requirements like down well enough to ensure that that's true. So my comment would be, and maybe we can put it in a comment bubble, that this section needs to be cross-referenced with that to ensure, like I said, that there's no conflict and that it doesn't go below the floor that's not now required in that area.
And I would also just say that we probably need to make the CalAIM references broad enough to allow the DHCS to change things somewhat rather than citing it, you know, verbatim, so to speak, but sections of to be in compliance with those types of things, because the implementation date and probably all this is just the final field operational guides, they will change some things, at least minor changes.
Thanks, Amanda. I liked Kristen's comment about where appropriate as we're going through the regs, to make reference to CalAIM and in some way, shape, or form, you know, aligning with, not, you know, not conflicting. I don't know, and I keep coming back to like kind of zooming out where and how CalAIM applies. And I don't know like if it goes into this section in particular. That's my first question. Is there a larger section like the healthcare procedures manual where that could be a more general requirement? And then perhaps like when we get into 1413 and we're talking about pre-release planning, maybe there's a nexus to that, the pre-release planning required by CalAIM. I'm just curious about whether, Meredith, you're suggesting that it reference to CalAIM goes in this section and or other sections as well.
I think that it does impact this section. And I think it needs to be considered in a comprehensive way that I know I'm not equipped to in the course of like redlining this section right now. So my suggestion would be that we flag this with a comment bubble and reference the operations guide that I provide the link to. I do believe that it has changed even post-release procedures enough that there could be conflict with this section, which does have a substantive standard and requirements around, you know, requests and written authorization. So I think it needs to be revisited here. I hear people saying they don't know, and I think that we collectively don't know enough in this moment to say that it doesn't.
Does anybody know a CalAIM expert that they'd like to send my way?
If we use expert loosely, no, I think that
You know, I actually think I recently saw a presentation on this, so I'm happy to see if my memory is correct and then forward that information.
I think at Youth Law Center, we've been doing, and it's not my area of expertise, we've been doing a fair amount of work around CalAIM, and I can also offer some resources.
And Allison, there was a webinar. I participate in as many webinars as I can around this as we're working within our facility to get plans in place and to make sure that, you know, everything that's, you know, that we need to either change or enhance or, you know, whatever, that we're doing that. So I received a pretty good, there was a pretty good webinar last week, and I got the slides and the recording of it today, so I can forward that to you. It's kind of in the vein of medication assisted therapy. There's a kind of overtone of it to it, but it's a pretty good guide that shows, you know, step by step. Youth enters the justice system, and then what happens after that in the eyes of CalAIM. So I'll forward this to you.
Okay, that would be really helpful. So the request really is a recommendation to look through, I mean, take a look through the regulations and CalAIM and find a way to reference CalAIM so that there's no, at least a statement that there's no conflict with, and reference to alignment with CalAIM where appropriate. It's kind of a lengthy statement there. And I don't know what that's going to look like. I'm going to be perfectly honest about that. But I appreciate the documents that we'll have, and we'll see what that looks like. Dr. Arguello?
Yes, I just wanted to offer that OYCR it has been working very closely with the Department of Healthcare Services, so we can provide perhaps somebody that can guide us in addition to us providing OYCI providing also some guidance on this issue. So I can send that to the group, the information.
Okay. And don't be surprised if we reach out to you directly as a member of the OYCR staff.
Please, please.
That would be really fantastic. Thank you for that.
Please do. Thank you.
So back to 1408.5. So just a clarification, Meredith. So we have it's not necessarily in the comment bubble there. We have the you know, the overall recommendation to look at CalAIM. We have the guide up and ready. I wouldn't be comfortable making a incorporation by reference for this manual into our regs, knowing that it's a work in progress. So I don't know, Meredith, can you clarify any other revisions that you want to see in this regulation, knowing that we have that overall recommendation captured?
Just the flag that this section needs to be included in that review.
Well, and I think what I'm gonna try to have us do too, when Kristen was talking about the slides from the webinar, it's gonna be helpful to know what areas apply. I mean, just taking a look at the table of contents in that guide, I mean, pre-release planning is gonna come up. Release of healthcare records is gonna come up. So maybe you know, as topics come up, you know, throw them in the CalAIM file folder, and we'll make a note of that. Otherwise, is this regulation good to go?
I think so.
If there's no objections, we can move on to 1409. Healthcare Procedures Manual. So this regulation is the requirement, again, it notes on-site healthcare staff, making sure that the health administrator is working with the facility administrator to develop a facility-specific healthcare services manual. And again, addressing at a minimum all the healthcare related standards applicable to the facility. It needs to be available to all healthcare staff, facility manager, and shall be reviewed every 2 years, revised as necessary. This is very similar to the to the operational requirement that the operations manual is reviewed every 2 years, and that there's a system to document that the manual is reviewed every 2 years. So just to kind of set the framework for what this recommendation, what this regulation does, it's very broad. It doesn't get into very many specifics. It's just saying this is the healthcare manual at a minimum. It has to address, I mean, every single section in Title 15. And open it up to any comments. And Dr. Arguello, I see that you have your hand up.
Yes, and I just want to get clarification. So this procedural manual contains medical, mental health, behavioral health, and dental information in it, correct?
Correct.
Okay.
So
thank you.
yeah, so
And substance use.
Yeah, behavioral health, mental health, yes.
And again, we have healthcare defined, and we can always come back to those definitions. We have healthcare defined as medical, behavioral, and dental as well. Joni?
Well, I think similar to my previous comments, I feel like the behavioral mental health director should also be a part of developing this manual. So my request would be to add the behavioral mental health director.
I was just looking at the definition for behavioral and mental health director. I mean, I don't see an issue with it being called out in here. I don't see an issue with it being called out in there. Kristen, do you have any specific insight or whether, I mean, I'm gonna make an assumption that the health administrator would include those if there's an issue with adding. So it would be like for juvenile facilities with on-site healthcare staff, the health administrator in cooperation with the facility administrator. Behavioral mental health director, and then I think it would be responsible physician to like get all those layers. Is there issue with calling those out?
I don't find issue with it. I think it may be a little bit redundant because what this is saying is that there's going to be a healthcare procedures manual in place to document, you know, all healthcare policy and procedures in the facility. And then within the individual policies, there's signatures by the behavioral health director, the responsible physician. Do you know what I mean? So I don't know that you need it. I don't necessarily see an issue with it, but I don't know that you need it in this section. That's just my opinion.
I mean, I'm looking further down in the section and it does not require the signature of the behavioral mental health director. I'm not sure if that's what you were referring to. It just,
No, I guess what I was saying is that, you know, this is calling out that any facility with on-site healthcare staff will have a policy and procedure manual that's available to all of the noted people here. And within that manual, all of the aspects of Title 15 in Section 1400, Article 8 are mentioned. And so there's, you know, sign off by the applicable. So like, for instance, the behavioral health director signs off on behavioral health related policies that are within this section. So again, I don't necessarily see a problem with it, but I don't know that you need to call that out here because this is just pointing to the fact that we're going to maintain a manual, a policy manual, right? Meredith, is your hand up?
Yes, I was gonna say, I agree with the edit. I think that makes sense to have these different folks participating in the development of these procedures. I also wanted to suggest a sentence that references the section we talked about last week around the healthcare monitoring and audits. I think it would be appropriate to tie the audits back to the you know, every 2-year review of the procedures. So adding a sentence that, you know, in this third paragraph, after the first sentence, that requires this review and revision of the policies and procedures, that this review shall include consideration of the reports and recommendations prepared for the healthcare monitoring and audits under section 1403. So I think last week we had a good conversation about making those audits useful. And I think that this is a very clear-cut place where the work around reviewing and improving procedures can be tied together. I did have a question, and maybe this is a question for Allison. Penal Code 13650 requires the probation departments to be posting their procedures, and I've seen that many are doing that now on their websites. I'm curious to know whether you would expect that these health procedures and manuals would fall under that, since they're part of the facilities procedures, but they're developed by, you know, they're the healthcare procedures and manuals. Mostly asking, do you think that's covered, or do you think that in order for these to be posted, there needs to be an additional requirement?
I'd have to look at the law. I know there's some exceptions to it. I'll take a look at it. I also want to mention, we need to stop using the chat to get recommended language, because the way the settings are set up, they're not visible to the public. So when we're making recommendations or sending documents, we can't use the chat anymore. So we'll just take recommendations verbally rather than using the chat. Thank you so much. And I don't know that law well enough. I can take a look at it. Like I said, I know there's exceptions, you know, for whatever reason. I don't want to assume. We'll take a look at that and we'll get back to you on that.
Okay, thank you. I just, my point being, I think it would be important for these aspects of the facilities procedures to be included in the public posting of the documents. So Amanda, I'm sorry, I can restate my sentence if that would be helpful.
Yeah, I think I lost you. I thought you said the second paragraph, but I think you might have said the
Third
third and I misheard
paragraph.
you.
Yeah,
After the
exactly.
first sentence here.
Yep, after the first sentence. So my suggestion is this review shall include consideration of the reports and recommendations prepared for the healthcare monitoring and audits under section 1403. Thank you.
Thank you.
13650. Okay, sorry, my eyes are really bad. Okay. I mean, it basically says if any Public Records Act requests were made, that information would be readily available. So my assumption, and Kristen and Amanda, and Kylie as well, I assume that would apply to all of the healthcare procedures as well.
I haven't looked at that section, so I don't feel like I can answer that. I don't know.
And we can get back.
I mean, what it requires is that if it's a PRA, it's a Public Records Act record, like disclosable under the Public Records Act, then it actually has to be affirmatively posted on the website. And so what I'm getting at is this probation's policy, this health procedure, and it's such that this section would apply. And if not, then I would suggest an additional requirement to post the health procedures.
So what I can say just by way of practice, like our policies that we maintain within the facility, the majority of them are specific to what the health services staff are doing. And there's many policies that intersect with probation and you know, calls out, this is what we do and this is what probation staff will do within the facility. So yeah, I don't know.
Joni, you had your hand up, and then I see Kylie's hand up as well.
You know, I just have a procedure question. We can address this anytime, but since we're doing this by consensus, how do should we be like affirmatively saying our support for any particular edit? Are we waiting for some other time, or you know what I mean? How do
I
we?
think, you know, what's worked well in some other groups is if there's opposition, somebody letting us know. I don't want to always assume, but I think it might help help us move along if we can assume there's consensus unless someone has someone opposes a change. If that works. So, you know, when we're kind of putting something up on the screen and getting ready to move along, we can make that comment. You know, is there any other comments or disagreements or opposition? If not, then we can say that there's consensus on that and move on. Does that help?
Yeah, and then it sounds like if there is disagreement, we can have like a bigger conversation.
Of course.
Yeah, no, that's great. Thank you so much.
Kylie?
I was just going to say briefly, in regards to posting policies online, our county council went over it. And the only ones that we have that are health services related that are currently available are Narcan, CSEC, and psychotropic medication.
I was actually Googling Sonoma County's policies to see if what was online. Did you just note what was online and what wasn't?
I have my own list that I utilize to make sure that when I update a policy, that if it's something that's on our website, that I make sure that I do that as well. So It just lives on a document right next to my desk.
Got it. And that would be, again, I want to make a note, and I was quickly looking at Sonoma County's policies. Again, like it wouldn't be BSCC inspecting to see that it's up there. That's the responsibility of the county to follow the law. I just wanted to make a note of that. That wouldn't be, that's not in our realm of inspection, I guess I would say. So it's incumbent upon each agency to make sure that they're complying with the law. I don't know if that changes any of the recommendations for revision to 1409. And I think the only other thing that I would add, if we're going to add the behavioral mental health director, is that we would add the responsible physician as well, because they're sort of the, you know, the under the umbrella of the healthcare administrator. You'd have the, again, these are meant to be, you know, terms that are flexible. So whatever that that level of person would be in the individual facility, I would assume you would want the corollary to the or the companion to the behavioral mental health director in a physician or nurse practitioner, whoever's in charge of the day-to-day operations, healthcare operations. Think we have a final recommendation here, if everybody could take a look at it, and if there's any disagreement or anything we need to change, please let us know, and if not, we can move on to 1410. Okay, 1410, management of communicable diseases. This is the requirement for there to be a policy for management of communicable diseases. This is interesting in that not only is the health administrator and responsible physician cooperating with the facility administrator, they're also coordinating with the local health officer to have these policies and procedures. So again, if you started a brand new juvenile hall, the health administrator would have to reach out to that county health administrator to develop these policies and procedures. At a minimum, identifying, at a minimum, having the identification, treatment, control, and follow-up management of communicable diseases. And then there's an A through G list of things that would be required in that policy. And again, I think this is a really important addition. Policies and procedures shall be updated as necessary to reflect communicable disease priorities identified by the local health officer and currently recommended public health interventions. Open that up for any recommendations here. Dr. Barnett?
Yeah, okay, you're gonna have to forgive me because I don't have specific language and it probably would be more relevant for another place. But from an infection control standpoint, I think this looks very good and I don't have other recommendations. From a youth development and rehabilitation standpoint, what we're seeing is that kids are spending a lot of time in isolation because of COVID. And then a lot of times they don't get their programming and they're basically stuck in their cells. So that might be something to think about because it's changed since the last time these regulations were revisited.
That's a really interesting discussion point because in our operational regulations for room confinement, there is a place where, sorry, I'm flipping through I have stuff all over the place. Please pardon me. Where if a young person has a medical order, and thank you, Amanda, it's the very last section. We talk about room confinement and how this section doesn't apply if there's basically an order to put that person in isolation because of a communicable disease. So what I think about, because I hear what you're saying, and I'll just put a giant period at the end of that sentence. There's got to be obviously a balance between protecting young people from one person or persons that have communicable diseases. And we probably learned a lot more than ever during COVID. So I don't know if in the communicable disease management regulation, there's a note about ensuring that room confinement or isolation is used expressly with the, orders by the physician and shall be evaluated regularly. Something to that effect, because it's a really good comment. And then again, if you could scroll to the bottom of room confinement, Amanda, just so people can see that section H, again, doesn't apply, because you can see where that would be appropriate, but you also want to make sure that there's reasonableness in that, those orders for isolation.
The other piece of it, I think, is if a youth is, has to be separated because for example, they're feeling well, but they've been exposed to a staff member who's tested positive for COVID. To the extent reasonably possible, that young person should be given books and other things that help them develop, thrive, etc. So I don't need to see, I don't think I'm not sure if there's a written change in the infection control section, but I just wanted to raise that because it's something that I think we're seeing across the state.
So I just wanted to add to that I think a lot has changed in terms of CDPH and CDC recommendations specifically for COVID and isolation/quarantine periods, masking, how to deal with an exposure, all of that kind of stuff. So I think that, in terms of an active case of COVID in the facility and how that's dealt with now versus, certainly 4 years ago, and how facilities are incorporating the recommendations of CDC and CDPH looks a lot different in terms of testing protocols and isolation protocols and intake protocols as far as gathering information when kids are coming in, whether it's COVID, TB, hepatitis, you know what I mean? There's a number of communicable diseases that we screen for at the point of booking. So the other things that you were talking about, having worked in a facility for a while and understanding what happens to a youth when they're even just, not in a locked room, but just isolated from their peers. Yes, we absolutely need to take into consideration how to help them manage that period of time, whether it's 5 days, 10 days, whatever. So working with our probation partners within the facility to take each individual case, case by case and what their unique needs are. In this section, though, I do think that it is a fair representation of what we want to have within a policy to make sure that we can manage if we come across any communicable disease that comes in and how we do that. So Yeah, I'll just leave it at that.
Just would maybe just like to make a comment as far as, because as you said, we faced this, but if there was something in there that stated if the
Oh, I'm sorry, Forrest. It's
management of
really hard to
community,
hear.
oh, I'm sorry. Something like if the communicable disease results in room confinement, policies or procedures as far as how the youth might be given certain, whether it's counseling or something of that nature, but just a suggestion about that, just something to think about.
Meredith?
I really like that suggestion, just to, it feels like the room confinement is dealing with like the specific instance when it's being imposed, whereas this is more about the policies and procedures. And I like the suggestion that, as a standard, the facility should be considering how to help youth manage any period of isolation. I was gonna start working on drafting that, but first I had a similar suggestion. I would like to see a line that says that the policies and procedures shall ensure that any isolation of youth with a communicable disease shall be no longer than necessary to address the health risk and shall conform to the community standards for preventing the spread of communicable diseases. Because my concern is that the easiest thing to do would be lock down for as long as possible, right? I am aware that some facilities were imposing isolation far in excess of what the public health standards were. And I think it is important, given what we've learned from COVID, that we reference community standards of care, and that it not be because of the detriment of the isolation, that it not be go beyond what's needed for addressing the health risk. So I can reread my sentence or however is most helpful to you, Amanda. But that would be my additional recommendation on top of what Forrest suggested.
Would you mind, Meredith? I was along those same lines, and maybe there's a way to kind of tie it together. I was looking at section G, where it says strategies for handling disease outbreaks. And again, keeping in mind that the health administrator should be working with the public, the local public health officer. But strategies for handling disease outbreaks, including isolation, quarantine, masking, testing protocols, intake. These are the things that Kristen had mentioned. Intake is up there, including isolation, quarantine, because those are medical terms as opposed to room confinement, to make it clear that when isolation or quarantine is used for communicable disease, that there's a specific policy and procedure. And then I don't know, that's kind of as far as I got, and I don't know if it makes sense, and hopefully Kristen could weigh in that, there's some connection to, I don't know if that would be different in every community. So, you had mentioned isolation no longer than necessary. Anyway, I was just kind of thinking out loud along the same lines of what you said to make those specific call outs in G as well.
So, and I think it's important. I agree with both Forrest and Meredith, but I really just want to highlight that the focus of this is the management of communicable diseases. And I don't want to, take away from our interest in making sure that, a youth doesn't deteriorate based on being in isolation because we're trying to manage a potential communicable disease outbreak. So I wonder if Forrest's recommendation would be more applicable in the room confinement section, in the section, and I think it was H maybe that you highlighted, that said because of management of communicable diseases or whatever, but that we're able to, and incorporating Dr. Barnard's recommendations too, that, we're providing, reading materials or, access to count, whatever it is. But let's just keep in mind that this section specifically is the management of communicable diseases. And to your point, Allison, there are some situations like, during COVID, there was about, I think it was 7 Bay Area counties that would kind of all make decisions together about how locally they were going to handle some of the recommendations. And that might not be the same as some of our more, eastern northern counties were doing. So I think specific recommendations about how we're making sure that youth are maintaining while they're in isolation because of a communicable disease policy would be better addressed in this section, because, we can make recommendations to probation about what might be, helpful, but ultimately they're the one, you're isolating that youth and we're saying, give them books, give them this, give them that. You know what I mean? So, that aspect of it isn't specific to how we're managing any communicable diseases. Does that make sense?
Yes, yes, I totally understand, and that is strategies for handling disease outbreaks. That's pretty broad in general, where it can encompass multiple strategies in the way of handling the outbreaks.
And then just, oh, Amanda, I'm ignoring Amanda F. And then I was gonna come back to Meredith's comment. Amanda F.
I hadn't followed your or Meredith's words exactly, so I copied the language from 1354.5 that we can manipulate, or I'm happy to copy down the verbiage that you all threw out there. I just didn't have time to get it down.
Yeah, and I
If
was
you
gonna-
don't see it,
perfect.
I apologize.
And then I was just gonna ask Meredith to go back to her recommendation about isolation no longer than necessary, where it goes.
I do think to the previous discussion, the experience of isolation and how to minimize the harm of that, I think you could put that in the room confinement. This section is about the policy for you handling disease outbreaks. I think that the handling of the disease outbreak should be tightly tied to what's needed, knowing that we're balancing against the harm that it can cause. So I like, ensure the policy shall ensure that isolation, and then we can look at this language from room confinement, is, utilized for the shortest amount of time required to reduce the risk of infection. That language is fine with me. I don't know about reduce the risk of infection. I don't know if we think of it the same way post-COVID, but something like that is capturing what I'm trying to suggest for this section. And Allison, I know you had some additional things, so I think maybe what I'm trying to do is combine what you're saying with what I was suggesting, and hopefully capturing the spirit of what Dr. Bernert was initially saying. So, but my recommendation is that does belong here.
Dr. Bernert?
Yeah, I agree with Meredith. Thanks everyone for your help with the language, and just to get us to specific language. I think maybe that clause that Amanda has in the comment, maybe it can just end at the shortest amount of time required, because it's understood that this is within the section.
Including policy that requires isolation for the shortest amount of time required.
Are you talking about adding another subsection? And I think I'm confused on whether we're trying to add a new subsection about specifically isolation or if we're trying to revise subsection G or the last paragraph. We're kind of hopping around a little bit.
I think we're gonna, and I'm looking at Meredith and Dr. Barnard. I think we're gonna just leave room confinement for now. We're gonna come back to that. But are you looking at adding to G something like strategies for handling disease outbreaks including, and we can figure out the perfect words later, including that isolation shall be used for the shortest amount of time required to stop the spread of disease or something like that? Are you saying G or another section?
I think it can go in G.
Okay.
So it would be including policies and procedures to ensure, maybe that's as far as I've gotten. And then I think we're working on that any isolation of youth be limited to the shortest amount of time required to, someone else can fill in the blank. address the health risk, or I don't know. Protect against the spread.
I think you could
You
just
could
leave
say-
it at the shortest amount of time required.
I
because
agree. I feel that same way.
These policies should have attachments that include the different strategies that are updated specific to the different requirements. Again, taking COVID into consideration, right? Dr. Barnard, is your hand still up or did it go up again?
Yeah, super quick. I think that looks great, great collaborative communication. I think it would be good if we added and quarantine. So to ensure isolation or quarantine is limited to.
You know what it is, Dr. Barnard? Your hand is merging with your picture in the back.
Yeah. Yeah, you can't
So
see
I
it.
couldn't tell, is that part of your yellow picture back there or is it your hand?
I never knew that because to me it's on the side with the blue picture.
Oh,
Oh, that's funny. Yeah, it blends in. It's funny.
You're telling me.
Yeah, so if we don't call on you, maybe just go like this or something. Use your real hands. Meredith, and then we're getting dangerously close to lunch.
I see that. I wanted to raise one last issue, and you can tell me if this belongs elsewhere, but I thought one thing that became apparent in COVID was that there needed to be policies for staff as well, because of the concerns of staff bringing diseases into the facility. And I haven't seen that anywhere else in the regulations, but my suggestion, if it belonged here, would be policy shall be developed for both youth and facility staff. And then maybe you can change the clause, the policies and procedures for youth shall address, but not be limited to, and then go on to these details. But that seems like a gap.
I don't think anything having to do with staff belongs in Article 8. I think that if there are specific things that need to address the staff working within the facility who are posted staff, that would be something handled in a different section. And I don't know if Kylie is available to weigh in on that or not, but I think that these policies that are developed here are specific to the youth.
That makes sense. I think it's a huge gap though. I would also think that the facility health staff would want to weigh in, and I don't know where else in the title regs that your health staff of the facility are weighing in on the health protocols for the broader facility staff.
Well, but we have to keep in mind that our health staff that are working within the facilities are not occupational health, nor are they the safety administrators for the counties, right? So we have within HR units for counties, that is who we looked to within COVID to give the guidance to the facilities about staff and about how specific safety measures were handled within facilities. So it isn't incumbent upon, you know, we hire staff to work, the healthcare staff to work in the facility specifically with the youth. So in terms of handling environmental issues as it pertains, like when we're talking about COVID and specific probation staff working within the facility, that isn't incumbent upon the health services staff within the facilities. So Kylie, do you want to weigh in on that and maybe talk a little bit about what we, you know, what Sonoma County dealt with during COVID, specifically with county HR and safety? And
Yeah, I had to step away, so I don't have, I apologize, I don't have the complete backstory, but it is a collaboration with multiple agencies to come up with the safest plan for youth and staff. And then my responsibility as a facility administrator is to hold staff responsible if they're not adhering to what has been set forth by county health or state organizations. But again, sorry if that's not applicable because I just had to step away momentarily.
yeah, part of what we were talking about here is incorporating into Article 8 requirements for staff, like as it pertains to management of communicable diseases. And my comment was that I didn't think it was appropriate to put that here, that it was more applicable to a section that dealt specifically with staffing on the probation side.
I would agree with that.
Allison, do you have an idea of where it could go? Because it does impact the health of the youth, you know, as compared to any other staffing sort of standards. This is very, you know, there's intersection here.
I kind of, you know, there's all sorts of workplace, you know, and worker safety protection and CalOSHA, all of those things that apply to workplace safety and certainly came into play during COVID. But I hear what you're saying about, you know, how do you prevent? I mean, gosh, I can't imagine. I can't even. We had a lot of conversations like, how do you handle people coming out of the community and coming to work in a detention facility and not bringing it to youth? And I don't know, and I'm going to just kind of put on a kind of a community-based hat now, because if the management of communicable diseases is in coordination with the local health officer, I mean, you can't necessarily manage what people are doing out in the community, but if the expectation is that everybody in the facility wears masks because that's, you know, that's the recommendation of the health officer, then the staff would be beholden to doing that. And again, it's tricky because our regulations don't cover staff. So I don't know how to come up with a regulation that protects young people if a staff member has a communicable disease, because theoretically it could be just about anything, not just COVID. So I think you have to fall back on the probation's oh gosh, there's a name for it. Maybe Kylie knows it. There's
aerosol transmissible diseases.
Precautions. Yeah, universal precautions. So again, I don't know that belongs here, and I see
Well,
that I'm going to have Kylie save me for myself in this one.
I was just going to mention that again, these are minimum standards. And so our job is to develop a policy that holds staff accountable to meeting these minimum standards. So again, if there's someone who is not doing something or following these recommendations appropriately, that's where I come in with some sort of discipline to correct the behavior to ensure that they are doing everything appropriate to keep the youth safe and the universal precautions that are necessary for the circumstances.
Well, and also to both of your points, when we're talking about all communicable diseases, there are certain things that counties and county administrators put into place for staff, whether it's probation staff, health staff, whoever's working within the facility. Aerosol transmissible disease policies, for instance, address certain aspects of it. There's yearly TB screening for all staff working within these facilities. So I understand the point that you're making too, Meredith, in terms of, the transmission, especially of COVID and what we saw during the height of it, right? But when there are recommendations put into place, whether it's by a health officer, CDC, or whoever, to Kylie's point, staff are expected to be compliant with masking requirements, for instance, PPE requirements if you happen to be working on the isolation unit. Like there are certain things that we put into place, and then, staff are expected to be compliant with that. And we rely on the health officer, our HR safety folks to tell us if staff have symptoms or are positive. What is the requirement of them, whether they come back to work, when do they come back to work, that sort of thing. So
which leads me to, I don't see why having a standard that there should be a policy like you've said you have. I don't see why that's a problem to include then if you do develop those policies for PPE and et cetera, why not for counties that maybe aren't as proactive as you, just having this standard that there be a policy, because it does implicate the protection of youth. And there's one more issue that I want to raise here. But again, it's hard because health things come up in different ways, but I don't see here notice for families when a youth contracts a disease. And I know that we heard that as a very serious issue during COVID, that youth would get sick and be put in isolation for long periods of time, and their parents had no idea. And so I wanted to raise that as an additional issue that's specific to communicable diseases. I believe there's notice around like transfer to external facilities. There's notice about serious injuries or deaths, but I don't recall seeing anywhere else in the code notice to families when a youth has contracted a disease in the facility.
So if since we're way past our time on the agenda to go for lunch, can we hold on to your recommendation, Meredith, and bring that up when we get back? That would be helpful. And we can all get some nourishment and refresh our brains and have some coffee if that's your thing. And we'll meet back here at 1 p.m. and we'll start with the discussion of what happens when a young person falls ill, and notification, and perhaps is in isolation as well. Thank you. All right, we're gonna put this meeting on mute, stop our recording, and we'll join back up at 1 p.m. Thank you. Okay, we're gonna call everybody back into the Zoom room. It's 1:01. Hopefully everybody was able to get some rest and nutrients and caffeine, candy, cookies. What's that? Yeah, we're all human. We'll wait for others to filter back on. Just waiting for a couple more people to filter on. It sounds like the apocalypse outside. I think it's just the garbage pickup, but in case we all disappear, that's what happened. Sorry. My
Well, I
mind just
hope you
goes
don't all
there.
disappear. That would be
It would be
terrible.
terrible. Be terrible. Sacramento apocalypse. It's very specific. I wanted to just we'll wait for others to filter in. Meredith, you brought up a point about um letting parents or guardians know when young people got ill, and particularly if they were in isolation. I wanted to point out, and it's also in our regulation package, section 1341 is requires policy and procedures for notification of parents if a young person passes away, or if they're ill or injured. I don't know if that covers what you're saying. I don't know that we should put an overall statement in management of communicable diseases when it appears elsewhere. It's typically the responsibility of the the policy and procedure is developed by the health administrator
Can you
and the
say the number
facility.
again? I thought you
it's
said 1431.
It's 1341.
1341.
Yeah. Yeah, and it's in the back. It's in maybe Amanda can pop that one up there, but it's in the package for our review as well. There it is. And it also, the revisions will also require that there's notification to the, in thinking of obviously older youth, if they have a spouse, their attorney, and the juvenile court if appropriate, just to encompass all of the potential people that could be notified if they were no longer a minor.
I'm just pausing on the serious illness, trying to figure out. That's not defined anywhere, I don't think.
So that would be the, again, I'll look over to Kristen and some of our other healthcare people. That would be the agency would have to determine what was a serious illness and when to notify. So it would be in their agency policies and procedures. I don't know that serious illness is a term of art or if it's just an umbrella term for agencies to define in their policy. Kristen, did you have any thoughts on that?
I think you summed it up. I think that this points to how notifications would happen. And I don't think that we have a definition of serious illness, and it could be considered somewhat subjective, I guess. But Kylie, what do you think?
I don't have anything different that hasn't been already shared.
I mean, I can speak to, obviously, again, and it's like a broken record, but what happens in our facility, right? Typically notifications like this come from a probation supervisor to the parent. If we identify an illness or an injury to a youth, and they are sent out, for instance, a probation supervisor contacts the parents to let them know, hey, this happened. Your person went here, kind of thing. I don't know that we could capture every single reason that someone would be notified under this if we tried to be really specific.
One of the scenarios I'm thinking of is like I mean, there's also a timing aspect, and if it's a communicable disease, you know, what if the parents had just been visiting? So it's not, you know, it's an important,
That would probably be covered in public health guidelines.
Yeah, like specific to COVID is because that's kind of how this came up, right? There are, and there continue to be notifications of close contacts, right? So that would, yeah. So that, I mean, if parents had come to visit and we determined later that night that the youth was COVID positive, then a notification would go out. And I mean, you know, it's not considered a serious illness, but I can point at things like scabies or lice too. That's an environmental issue, right? So if we have a youth who came to us with lice, for instance, and we treated them and they no longer have lice, we would want to contact the parents and let them know, hey, you know, you may want to check your environment because this is how this gets spread, right?
yeah, I guess that, I mean, that exactly speaks to why the current reg doesn't address it, because right now there's only notice on serious illness, and that doesn't necessarily encompass what we're talking about. I think both when a youth is in isolation and when there's something that could that's like communicable, and the information is important to share.
I feel like, and we talked about this during COVID as well, because there were communicable diseases, or there are communicable diseases that predate COVID, right? And so all of those are handled. Like if TB, you know, happened, or, you know, the H1N1 was an issue for quite some time. I feel like the intent of this regulation, and we did a lot of talking with our agencies, both adult and juvenile, about this. The responsible physician must work with the local health officer, and the local health officer must outline, there's lots of protocols for residential facilities, whether it's a detention facility or a nursing home or other sort of residential placement. There are public health laws that mandate notification when there is close contact. I don't know that it needs to be specifically called out when the whole reasoning, the whole intent behind this regulation is that there is this policy. But I don't know, you could put everything in regulation and still forget something, knowing that, again, it's the responsibility of the local health officer in that county to make sure that notifications happen. So I don't know how to think about a regulation that requires notification. I mean, you couldn't just have COVID. It would apply to everything, which is why this policy is so broad. I don't know, I'm babbling a little bit. I'll look over to medical people to think about that a little bit more. And what happened during COVID. And I guess if there is harm in adding something there, but I just get nervous about adding everything that should be covered in a local health officer's directive in a specific regulation. Currently recommended public health interventions. I don't know. Yes, please. Thank you. Joni?
I mean, is this one of those things that we can kind of put in a like a bubble and think about? I mean, I also you know, I can see what everybody is saying, and that there should be policies already in place to communicate this information. And I think the concern is, I mean, it seems to me it's not harmful to include it, is what I'm hearing. And it may just ensure that that information is communicated like quickly and appropriately or whatever. So I'm wondering maybe if it's okay to just have something in here that we're considering and we can come back to, or.
I mean, I'd rather figure out what we're gonna do, and maybe if you have a specific recommendation, or Meredith, you have a specific recommendation. I mean, it could be something as simple as in the last paragraph, policies and procedures shall be updated as necessary to reflect communicable disease priorities identified by the local health officer, including notification of close contact, or I don't know what the terminology is. If that, addresses, I don't want to make things COVID specific just because, I'm sure there are public health laws that apply to other, communicable diseases. So I don't
There
know if
are.
that's, or Joni or Meredith, you have a, specific recommendation. It would be helpful to see what we could do here.
Can I ask a question? What if you just included in that section 1341 that you just had up, communication regarding, bringing it back. So down at the bottom, where it says facility administrator in cooperation with the health administrator shall develop written policies and procedures in the event of a serious illness or injury, including communicable diseases of a youth. Would that cover it?
Thoughts?
I think that works.
Yeah, because you're right, Alison. There are certain, I mean, if we had an active TB case that we found in the facility, it would be highly unusual. But if we did come across something like that, there are definitely requirements around notification and then screening, and so if that covers it, then great.
I like it. Dr. Barnard?
So item G. Oh, sorry. Where were we before on the including the serious illnesses? Could we please go back to that screen? So the problem is that not all communicable diseases are serious illnesses. Like if a kid catches a cold. So I'm not sure if specifying is helpful here.
So that's why we just added it, because it still says in the event of a serious illness or injury of a youth, including communicable diseases.
Right, and I'm
So
saying that most communicable diseases aren't serious illnesses.
Right, so we're adding it to that, including communicable diseases. Serious illness, injury, and communicable diseases.
So
Okay,
Dr.
there you
Barnard,
go.
so do you want to include a communicable disease that's not serious? Because that could be like a cold.
Yeah, I think that's a much larger conversation about what's feasible and what makes sense to communicate to parents. But Kristen, you did fix it like with the and, but yeah, there is a question of what communicable diseases would you notify them for?
And now it says only those that are serious.
So what would you
Okay,
suggest? Do you have a suggestion, Melinda or Dr. Bernard?
You know what? It was my reading that like I wasn't seeing that the communicable diseases falls under serious. I was reading it as all communicable diseases. So if that's clear to the lawyers, then I'm fine with it.
And I agree.
Sorry.
I agree too. I like the language as it is.
Okay. Now that we've taken care of 1410 and 1341, we can move on to 1411, access to treatment. Again, this is like the prime example of a performance-based regulation. Again, the facility, the health administrator in coordination with the facility administrator has policy and procedure to provide unimpeded access to health care. Looking for any feedback? Jody?
You know, this has come up in other contexts. In terms of SYTFs and treatment that is outlined in the individual rehabilitation plan, I mean, this is one part. If we're defining healthcare to include behavioral and mental health, this again is kind of an area where we could talk about, you know, policies and procedures to provide those types of services, the ones that are outlined in an individual's IRP. But I can also see, I can anticipate that the response is, look, that can be done somewhere else, and that's fine. But we need, in terms of SYTFs, we need to talk about what about those individual needs that are not like readily available in a on-site healthcare, you know, in the on-site healthcare that's provided by a juvenile hall.
I think my response to that would be hang on until we get to 1413. And I really think that that conversation about what may be in an IRP could be translated into a young person's individualized treatment programs. This is again, a broad regulation that covers and ensures that unimpeded access to healthcare. I don't know that this regulation should cover everything that's offered. I think 1413 is going to be where there might be some nexus between these regulations and the individualized rehabilitation plan.
Yeah, and I mean, when we had discussed this before, I mean, my memory was I brought this up with like 1401 or something like that. Or we brought it up in a different context. I don't think it was 1401. I just want to make sure that, because the way I read 1413, it's about the individualized treatment plans as opposed to the policies associated with ensuring that that treatment is available. But again, I'm happy to address it in 1413 if everyone feels like that's the more appropriate place to do it.
Yeah, you know, again, I'm just going to speak for myself and my struggle. I read a little bit more about the individualized treatment plan, something that's required in statute, that is prescribed by the court, that the probation office has to follow, where a component of it could be mental health care. I just hesitate to call that out in a specific regulation that's so broad about unimpeded access to healthcare. That's my feeling. Again, it's in that spirit of not wanting to duplicate. And Kristen's talked about also how there might not be control, not necessarily control, but if something is called out in a young person's IRP as far as mental health care, there's a different level of responsibility to follow that. Might be part of the mental health services available at the facility. I don't know.
Well,
That's
an
my
example of what you might be talking about, Allison, is, for instance, if we have a youth who in their IRP, it's identified that they need juvenile sex offender programming, for instance. That isn't programming that all facilities are going to have their health care staff or their healthcare unit providing. They could, but in most cases, it's probably not going to be the responsibility of that group. It's going to be, you know, someone that perhaps probation contracts with. So the program that they're under that's spelled out as part of their IRP that is going to get reported back to court and is going to go back in terms of their participation and how they're progressing through the program is very, very different than a youth participating in individual therapy with the behavioral health clinician that's on site at juvenile hall. So the programming that goes into the IRP is what the court and probation put in place, and isn't, you know, the way that 1411 reads to me is the youth having access to the healthcare that's provided within the facility, not necessarily the programming that they are being mandated by the court to do, which should be different and separate.
Oh, I see. I mean, it sounds like you're making a distinction between, you know, the services that behavioral health is kind of offering and making sure that people have access to that service, as opposed to what the court has ordered is an individualized, like has ordered this particular service must be given to this youth. And in that situation, it's not behavioral health's realm, right? That is more probation's realm, is what I'm understanding you to say.
Well, in most cases, yes, when we're specifically talking about the IRPs. So there's programming, as I'm aware, that goes into the IRPs that is very specific to the individual kid. That could include like JSO services. It could include gang intervention services. Like there's different needs that the youth present with that the court says you have to complete all of this. And we're going to come back every 6 months. We're going to review it. Right. And that, in addition to that, there are services provided within our facility by behavioral health clinicians specifically, by the medical staff specifically, by the substance use counselors specifically, but it isn't prescribed, if you will, by the court. It isn't the court stepping in and saying, you must participate with the behavioral health clinician that works in juvenile hall.
So I think that there are actually three categories, and the one, and because there are three categories, it seems to me that there should be a written policy and procedure about how to access healthcare, you know, this broad umbrella of healthcare in each of those three categories. So and 1411, really what it says is that the health administrator and the facility administrator together develop these written policies and procedures. So one would be, you know, a treatment that traditionally probation is responsible for and provides for. SBTP programming is a good example, right? That your juvenile hall or a juvenile hall mental health team may not be qualified to deliver that kind of service, right? And it may be that for whatever juvenile hall you have, that the health administrator and the facility administrator agree that probation is going to take on that responsibility. And then there is non-court ordered therapeutic services that are available at juvenile hall. I think I agree that that should be covered under 1411. It sounds like you and I agree with that, but there's a middle category there's another category of services that are court ordered and are provided by behavioral health or expected to be provided by behavioral health, at least in my experience and in talking to other defenders in California. And so I just want to make sure that there is some policy. I think as we're talking about this more, I feel like 1411 might be the right place to put this, because again, it seems to me there are these three different buckets, and it might be helpful for, you know, mental health and the facility to kind of work out who's responsible for what bucket. I mean, that communication needs to happen. Otherwise, that middle group of court ordered and expected to be provided by juvenile hall mental health, I don't see how that gets provided effectively.
Joni, could you give an example of what you mean that is court ordered specifically for mental health staff within a facility to do? Like what would be court ordered specifically for mental health staff?
Individualized treatment to deal with PTSD and trauma specifically. Trauma-focused treatment is one. I mean, that can be a really rehabilitative need that is identified by the court. The court can order it. The court expects juvenile hall mental health to provide it. And there needs to be some, if you don't have clinicians on staff that are qualified to do that, there needs to be a plan in how you provide that treatment to youth.
So I would love to hear Amanda's, and I know Kylie, you've had your hand up for a while. And I guess if you have a situation where the court is ordering something like that, but the youth is not interested in participating, I would wonder how we would achieve that. So,
I do just have I'm really curious about this because that particular comment comes up a lot. The kid is not engaged or doesn't want to, right? And I mean, there are two parts to this. As a parent, like, I don't know if there are a lot of kids who like want to spend time at therapy and I just think that what we say to children who are not in a custodial setting is you need to do this. This is non-negotiable. You will be going. I don't care if you sit there and stare at the wall, but you need to go. And it's on the therapist, at least, the hope is that the therapist will work on building rapport and work with youth to help, engage the youth in that therapeutic relationship. But sometimes what I hear is, youth in custody who are ordered to do mental health treatment or to engage in individual therapy, that they're approached and they say, hey, do you want to do therapy today? And the kid says no. And they're like, well, he doesn't want to engage. And I just think that isn't, it seems to me that there's a real disconnect in the expectations that we put on the relationship between therapists and youth who are in the community, and then therapists and youth who are in custody. And I just feel like that's a real missed opportunity, and we're not addressing a kid's rehabilitative needs. Okay, I'm sorry. That was just that's come up a couple times, and I just want to point out that there's something about that that's kind of floating around here when we're talking about therapy in custody.
I want Kylie to speak up. I'm really interested to hear what she's going to say. And I also want to point out that we would have a really hard time regulating the relationship between a therapist and a young person. Kylie?
I was just going to mention that this feels better suited for 1355 or 1356 because this is essentially a case plan for long-term youth. So it already in 1355 discusses, having the plan include input from family, supportive adults, youth, and regional center for developmentally disabled. And so if health services goes into that category as well, I think it could be helpful. And just a quick side note on therapy and custody. We do not force youth to do anything. And so even if we said, hey, you have to go here, we're going to build some rapport right now. That's not beneficial to the youth, the therapist, or the staff that are trying to serve that person. And they understand the importance. And that's why you have a dedicated caseworker who's spending time with that individual, reiterating what the court's expectations are and how to best move through that treatment successfully to no longer be in custody. So I will keep it short at that, but I think we should examine maybe just an additional person or additional aspect in 1355 or 1356.
Amanda, why?
Yeah, I think there's a couple of things to unpack here. The way I conceptualize this access to treatment is, and the treatment that we do as a voluntary treatment provider, versus court-ordered treatment. We often we offer services, but that doesn't mean we stop trying to engage youth, even if they decline at that particular time. Our protocols and process relate to behavioral health staff check in anytime there's a room confinement. Behavioral health staff meet with the youth to ensure their safety, at least in our facility. I'm assuming this comes from regulation as well. Title 15, because that's the way our policies have been developed. So we go check on the youth. So we don't just stop engaging with them, but I think, and whether this is a holdover from outpatient treatment, and i.e. the billing aspect that comes along with outpatient treatment, where you used to, if you did not meet medical necessity, you could not get paid for the service. So again, I don't know how we've come to make this distinction about, but all youth in this facility have access to mental health services. Now, I think the example of sex offender treatment, let's say it's an eating disorder treatment, then those are specialized things that we might have to bring someone in from the outside to provide. The court and probation contract with a sex offender treatment provider, because my staff don't do that. Because we don't have the training. And again, that's a court ordered thing. And we are providers of voluntary mental health services. And I think that this is a good distinction, because when we are providers of voluntary mental health services, we are beholden to the youth as our client. We are not beholden to the court. Now, so then they might subpoena our records for whatever purpose they choose to. However, our primary responsibility is to the youth and protecting their confidentiality and their treatment plans. So I think those are how we conceptualize the difference and where our alignment is. We've had the court order our psychiatrist to develop a report that makes recommendations for, let's say, placement or aftercare services. Well, again, as a voluntary, we are treatment providers. We're not making professional placement type recommendations. And those are the hairs that we split, so to speak, that keep our alignment with the youth.
I think that's an important distinction that you're making, Amanda, just in terms of the way that mental health staff that are assigned to a facility are able to provide meaningful services to the youth and do that meaningful work. It makes a huge difference if you have a clinician who's meeting with you and allowing you to kind of, figure out what that's going to look like for you while you're in confinement. The services are absolutely available to anyone that's in the facility. But I can't tell you how many times, at least to my staff, the kid has said, I'm ready to meet now because I have to go to court and it's going to look good when I'm in court if I tell them I've been meeting with you. So, Melinda, did you have your hand up?
Sorry, if we're ready to move on, I just wanted to lift up the comments in the YLC's attachment B, which gives some really good examples of how to empower youth to make sure that they do access the healthcare that they know of and are able to access the healthcare that they have available. And so I strongly support these, and I think we should consider them. I can read it out if it's helpful.
Yeah, which one?
Yeah.
Specifically.
Yeah. I had it a minute ago. So at the end, we would add, including but not limited to A, how youth will be made aware of the treatment available on site and in the community in an age-appropriate way. B,
What page are you looking on attachment B? I'm sorry to interrupt you.
it is page 15.
Okay. So what's on the screen now?
Yes, exactly. Yes, perfect. Thank you. I don't need to read it. Thank you.
Okay.
Yes, that's what I would support adding. And I particularly like that it empowers youth to know what's there.
I'll zoom in a little bit so y'all can see it. I know it's really, really tiny, but it's this here in the middle.
I just have a quick question is for other people who are working facilities, we have some of this information included in the handbook. So
Yeah, it's a requirement in orientation that access to care and services provided and how youth can access those services is required. I forget what the section number is.
I believe how to file a grievances in that too. Maybe Kylie could speak to that.
And grievances.
And then the other part in here that I wonder about, how youth will be made aware of the treatment available on site and in the community. So I'm not sure how we would speak to that during an orientation process.
As I understand it, some facilities don't have on-site, the full range of on-site services, so youth have to go on off-site.
Oh, so you're thinking this is pointing to if you don't have on-site services, then how this will be made available to you. Okay, thank you for clarifying that.
And again, just again, I know I sound like a little bit of a broken record here. This regulation is so that healthcare providers develop policies for unimpeded access to healthcare. In other sections in Title 15, there are operational requirements. One is orientation so that youth, and we can certainly revisit that and make sure it's very clear that the requirement is in the youth handbook that they have access or they understand what is available. And then as far as complaints, it is covered, and specifically with medical care is covered in the grievance policy. So again, to make sure, like the goal here is to make sure that youth understand how they can have access to services and also be able to file a complaint. That is somewhere, and it's located in the operational section of Title 15. So I just want to point that out. Again, I just want to repeat that this regulation is for the healthcare administrator to develop policies for unimpeded access to healthcare, and there's other areas of Title 15 that call out how young people are made aware of that. Dr. Arguello?
Yes, I just wanted to mention that the intent of this section, as we have discussed, is access to care. So for me, okay, the complicated factor here is that behavioral health services can be provided by probation. It can be provided by, behavioral health staff, and they overlap. In some facilities, some things are provided by, a probation. In others are provided by behavioral health staff. So whether or not they're core mandated or not. So for me, if we want to increase access to care, we should include anything that is needed, for the youth wellness and for the youth success. So I don't see why we couldn't say not to provide unimpeded, access to healthcare. You could included services provided by probation and that are core mandated. So again, the complicated factor is that behavioral health services can be provided by other individuals that may not be behavioral health staff or mental health staff, and they are providing behavioral health services. Thank you.
Also, just to add a little context, with Allison had referenced some Title 15 regulation and 1353 orientation indicates orientation shall include information that addresses, and then you go down to F, access to legal services and information on the court process. G, access to routine and emergency health and mental health care. So it is addressed and should be in policy for the orientation of youth for the facility. So there's something to keep in mind that it is in that location as well. And the one 1411 is just saying have access to treatment, and 1353 is going into more detail with having a conversation, and in some facilities they actually sign off that the kid have been it's been discussed with the youth. So just want to provide that other area where this is located, where the youth is informed that they have access to that medical treatment.
Meredith?
I wanted to bring up here the National Commission on Correctional Healthcare and their standards for healthcare services in juvenile detention and confinement facilities. The first thing to note is I think we're falling below this national standard because this section requires policies to provide access, whereas the national standard is that youth have access to care to meet their medical, dental, and mental health needs. So I just want to point out that there is a discrepancy with the national standard. And more importantly, I want to suggest that at a minimum, we include what they define as access to care, which according to the national standards, it means that in a timely manner, a patient can be seen by a qualified healthcare professional, be rendered a clinical judgment, and receive care that is ordered. So my recommendation is that we include those further definitions there.
I may be, excuse me, I'm not sure if this will be helpful, but 1433 request for healthcare services. It kind of goes into what you were mentioning, Meredith, I believe, in terms of access and requests and the ability to receive particular healthcare services. So that's another option. I'm not sure if that covers, addresses what you mentioned, but that is a section where I believe a lot of what you indicated may be helpful there.
I do think that's helpful because it's a way to make the requests. I think where I'm headed is defining what the care is, which is care provided in a timely manner by a qualified healthcare professional, and then to receive the care that's ordered by that professional.
Can I ask a question? If in regards to an outside agency, regulating that the patient has to be seen by that outside agency can get a little sticky. because I know as a facility, they can provide access to that third party. But if that third party can't see you until they can see you, how much control does the facility have over that? If they're the one following their policies and procedures to provide that access, but that provider can't see them in what the facility or the youth may consider timely.
Well,
was-
that
oh.
that
Oh, I
does
was, oh,
come up.
sorry.
I was just gonna say that does come up, and I think that we have to, if we have, for instance, a situation where we are referring a youth to an outside provider and the youth wants to go right now today, barring an emergency that would require treatment in an emergency department, if we can't provide that specific service on site, then we would absolutely schedule them to be seen at the next earliest opportunity with a provider in the community. So it may come up that there's not alignment between what is available and possible versus what a youth may want in an immediate sense. And I think it comes down to meeting their specific needs the best way that we can. Does that make sense? For instance, if we have, again, an emergent situation, that's going to go to the emergency department. But if we have, for instance, a complicated dental extraction that our dentist, we need an oral surgeon as opposed to our dentist on site to do, we're going to arrange that with the oral surgeon in the community so that it's handled in the best way possible for that youth's health. But it may not be possible to schedule the very next day. It may have to wait a week, right? Just as we would for anyone in the world trying to get an appointment for something in the community.
And the National Commission uses as a compliance indicator that the responsible entity identifies and eliminates any unreasonable barriers, intentional and unintentional, to the youth receiving care.
Mm-hmm. Can you read that again, Meredith?
Yes. Compliance indicator, the entity identifies and eliminates any unreasonable barriers, intentional and unintentional, to youth receiving care. So
Can I
I
ask a
think
silly question? Wouldn't
translating
that
that
be
to our
unimpeded
system.
access?
Right, so that's the compliance indicator. I know you're often, emphasizing that we need to look for, tailor our suggestions to what's inspectable. And so that's the inspectable indicator, according to the National Commission.
So in the regulation, and again, keeping it broad, and I'm going to use Kristen's example of if, a not very well resourced county, if a young person requests care that's not emergent, there might be a wait to get that young person to.
Did Allison just freeze?
I think so. Allison, your audio cut out
That
maybe?
And you're not
in my
moving.
mind, the facility admin. Oh,
Oh, there you go.
I don't know what to do. Am I moving now? It was really brilliant. I think. Am I back?
Yes,
You're
you
back.
cut
Okay.
out as you were saying emergent or non-emergent, I think.
Yeah, so in that agency, they have to define what that, unimpeded access is. So you'd want to see, I hear what you're saying, like there's a difference, I don't know what I'm saying anymore. I just feel like, unimpeded access is the standard, and now each agency has to define what that means for them in a really well-resourced county with 24/7 medical care. The unimpeded access is the young person's going to go to the clinic and get that, issue taken care of or looked at right away. But unimpeded access in another county might be when medical staff return the next morning at 8 a.m. Again, if it's not an emergent need. So again, that's what we would look for, again, in, determining compliance with unimpeded access. I mean, sure, you could put the words in there that they remove all barriers to healthcare, but it kind of still says the same thing,
I think just to be clear, I was reading the indicator, so that's the inspected standard. But the regulation would say access to care means that in a timely manner, a patient can be seen by a qualified healthcare professional, be rendered a clinical judgment, and receive care that is ordered. So what I'm actually going towards is not the unimpeded part, but access to healthcare and what that means according to the national standard.
I'm going to say something might not be fantastic, but to me, I mean, we could certainly, you could adopt what NCCHC is saying that their standard is and put that in there. I mean, I don't want to be difficult. To me, that still means unimpeded access. Like I said, in an under-resourced county, that unimpeded access is going to be 8 a.m. when the next, because between, 8 p.m. and 8 a.m., there's no on-site medical care. So the, quality, as soon as possible, all of those things, that is that county's definition of unimpeded access, or, I forgot the other word. So, I mean, we could put that language in there if there's appetite for it. I think it's, it lends a little bit more specificity. But again, the ultimate, what we're looking for here, I think, and then I'm going to always, pick on Kristen for this one. What we're looking for is that the facility identifies, I mean, you could even say that, how quickly they're going to get young people to healthcare in a non-emergent situation. I don't know how many different ways to say that.
Well, and I think that this, because we're talking about issues that are in other areas of Article 8, right? Here we're talking about a policy that provides and how we're going to provide the access to the care, right? And then there's a whole other section that deals with how the youth can request care, and how that's communicated to them in terms of how they access it and how they request it. So I'm not sure.
This is, so, I mean, the national standard is access to care. This is called access to treatment. It's the same section. It's the same concept. Like, what is the care that's being provided? And the care is in a timely manner. And I think timely is dictated by how emergency or not, that's a time, that's, is it serious? So it needs to be immediately addressed, or is it something ongoing that, we can address over time? That's a time standard. So it says timely, it's timely to the issue. And then who, by a qualified healthcare professional who renders clinical judgment, and you receive the care that the qualified person says you should receive. That's access to care. It's defining what that term means.
Do you want to add, maybe give us some language and we can type it in and see what it looks like?
Yeah, sure. I can just read.
Definitely don't pop it in the chat. Just please,
I will not,
read
I
it to us
promise.
and we'll.
Is it also possible, excuse me, just going back to 1433, request for healthcare services, before we make changes to this 1411, to look at 1433 first, in E, provisions shall be made for any youth requesting medical, dental, and behavioral health care attention or observed to be in need of health care to be given that attention by licensed or certified healthcare personnel. And at the end of that, it can say within a, you know, you can pick the wording, but within, you know, a reasonable time period, or maybe a word or something could be added to the end of that sentence in E instead of changing a lot of verbiage in 1411.
Well, and maybe you just reference 1433 because 1433 is very, very specific. Develop policy to establish a daily routine for youth to convey requests for emergency and non-emergency medical, dental, and behavioral mental health services. I mean, that's very specific, right?
And it's access.
And then it goes on from there. There shall be opportunities available on a 24-hour per day basis for youth and staff to communicate the need for emergency medical and behavioral mental health care services. So there's one even more specific just for emergencies, but up above, it's all.
I hate to point out that this says request. It doesn't give any guarantee of care. It says attention. So I'm a dentist. Oh, I see you do have cavities. Where does it say that you get the care? I don't think it's a coincidence that the national standards and our Title 15 standards have a section on access to care. And it's separate from making requests for care.
So these regulations are the guide that facilities use to create their policies and procedures in line with the availability of services. So that's going to look different for facilities that have on-site medical, dental, and behavioral health care staff versus a facility that doesn't have on-site, right? Because if you don't have on-site providers, you may have to make those appointments. Or if you have a dentist that comes on site, maybe the dentist is only there every other Tuesday. So if you have an emergent situation, you would have to reflect in your policy how you would deal with an emergent situation versus routine referrals that go to the dentist, whether it's because of a time frame established by Title 15 or because the youth requires some sort of treatment that's non-emergent, right? So this is the guide by which facilities demonstrate through policy what that access looks like. Does that make sense?
And the national standard is to set a floor as to what must be made available, whether on site or by some other means and in a timely way, so that if it is an emergency and a facility without on-site services knows and has planned for how they're going to address those needs, and for something that's not an emergency, how they're going to address those needs. Right. It all comes back to access to care and what that care is defined to include.
So I have a question.
You're falling short of the national standard, and that's like, I can read you the language if people are willing to consider putting it as the standard for care as opposed to the standard for requests, because that is what the National Commission has done.
So I have a question for BSCC staff in relation to the national standard and how that informs the Title 15 standards that the state comes up with, that the state of California, right? Because we have national and then we have various states that probably look to the national standard for guidance. So how does the state incorporate or not the national standards?
So NCCHC is a, you have to purchase their standards. So in order to have access to them, you have to purchase them. I don't have them in front of me. It's a member organization group. So we obviously, you know, I don't have them with me. I think I said that like 200 times. There's certainly a reference point for best practices, but again, that same, if a best practice if a minimum standard can meet a best practice, then that's what we're going to strive to do. A lot of the times, minimum standards and best practices aren't aligned, and that's not a fantastic thing. But again, our regulations need to be reasonable. I I'm not looking at them, so I can't speak. I hear what Meredith's saying. What I keep getting stuck on is that there's no regulation that says, and maybe there is, but if I could maybe boil it down a little bit, I think what I hear you saying, Meredith, is that there's no standard that says kids get the actual care that's available at the facility. Which I don't know if that's what you're looking for. I don't know if it should be in this section. I'm kind of like thumbing through some other regulations because I'm trying to identify the what the problem is with 1411 that we're trying to fix. And if the problem is that youth, the problem is in California, youth aren't actually getting the services by a licensed healthcare provider that the facility provides, that's a different situation. So I'm just kind of trying to bring us back to the intent of this section in 1411 and how to come up with a regulation or a language that addresses the issue that you're saying, which is there should be a standard that youth get the care that the facility has in a timely fashion rendered by a licensed person. So there's a couple different issues I see. I'm gonna ask Dr. Barnard to speak up. Maybe you can help me out.
For sure. Allison, I think you're framing that very well. I agree with what Meredith is saying, and the way I understand it is she's basically encouraging us to include a definition of what access to healthcare means. And in terms of what the problem is in California, I do think the issue is the youth not actually receiving the healthcare. So the facility may have the services or the ability to send someone to the community, but kids may be spending a long time on wait lists, et cetera. So, and the NCCHC standard, which I do have in front of me, so it's helpful. I can maybe help say the parts I think are missing. This set of regulations has things in different places. So maybe if we dissect what might be worth adding to 1411. So the access to care, the NCCHC definition, as Meredith said, includes in a timely manner. So I think, Allison, you're pointing out maybe timely manner is already implied under unimpeded. I'm not sure. I think that's something for us to decide together. Be seen by a qualified healthcare professional. To me, I think we probably do cover that in other sections, and maybe it doesn't need to be added here, or maybe it should. So we have one definition in one place. Be rendered a clinical judgment. So this is the part where it actually gets into the receiving care part that I think might be worth including. Be rendered a clinical judgment and receive care that is ordered. And then just a word on NCCHC for those of you who don't know about it. I'm actually the chair of the Juvenile Health Committee of the NCCHC. I spent the last weekend with them at the conference. Yeah, facilities pay about $5,000 on average to go through the accreditation process. But the NCCHC, it's a nonprofit really trying to fill a gap. And to the extent states, jurisdictions are able to include those standards, even without purchasing the materials, I think that NCCHC, it's a mission-driven organization. So the extent that the framework is helpful, NCCHC would like it to be used.
Thank you.
I have some hesitation with qualified healthcare professional, given the conversation early on about Medi-Cal, CalAIMS, and you all know those will be changing. They're getting a lot more broader on who falls into this category. And a term like that, having worked for healthcare services previously, can get a little sticky because they use their terms when they go to do their inspections to make sure things are in compliance. If something about qualified healthcare professional, clinical judgment, if we're broadening who those folks may be, could we be pigeonholing ourselves into something a little bit more narrow by including the baseline there? I also want to, on that same note, when it comes to identifying and eliminating barriers as that compliance measure piece, that's something I'm going to keep in mind for 1403, because it might be something for that monitoring and audits piece, as opposed to changing how we're defining healthcare here or access to healthcare. just two pieces to think about.
So going back to, thank you, Amanda, going back to, and I'm just going to pull up. Sorry, I was looking at the term that we use in Title 15 because we can always figure out what that is to be really specific. Is the, I guess I hear a recommendation to add to shall develop written policies and procedures to provide unimpeded access to healthcare that includes, and again, we can get the words better later, that is in a timely manner. I don't know how to say it out loud, grammatically correct, where the judgment is rendered and the youth actually receives that care. I don't know that there is, that is a possibility if we could work on some language. I don't know, Meredith, I know I asked earlier if you had the words that we could attempt to put in there. Go ahead, Amanda.
Well, could we just say unimpeded access to health care that and is provided timely? I mean, it kind of,
How do you inspect for timely though? What is timely?
see,
Like, how do you?
it's all going to, unless you literally have control of the service, and even then you can't.
Right.
I mean, in industry standards as available, all of that stuff is, you can't inspect to it, because if we say someone must have access to non-urgent care within 24 hours, then that may or may not be available given the local resources, like you're saying, with these difficult kinds of, i.e. the dental, complicated extraction, oral surgery kind of thing. So other than that, I don't really have any good suggestions. And I think, kind of to Amanda's point earlier, in the language and who can provide mental health services, rehabilitation type of thing, those are, not master level, those bachelor level people, and it'll come up again when we get to the mental health services of 1437 as it relates to the screening. Who's doing mental health screening? And I know that there's been community input that they want licensed or mental health professionals to do screenings upon admission, which makes it difficult at 3 o'clock in the morning to accomplish some of those things. So I don't know how we really quantify and determine how we are going to inspect for people to receive timely services.
I would just be more concerned about what my definition versus your definition of timely is, right?
And that's also going to depend on the local resources. You in Sonoma
Correct.
County may have different resources than I do in San Joaquin County, and that certainly have different resources than they have in, San Benito or Amador or someplace else. So I'm not sure we can quantify it.
Could it be consistent with the recommendations of medical staff? Because what I find is that doctors say you should be seen and then you're not. That's the slippage. So I'd be willing to go with what the doctor says. But the